Mrs. Franco will be replaced by... She'll take the floor.
Good afternoon, dear colleagues. I recommend to start because we have a long agenda today, 17 points, and I think that Commissioner will come soon and will join us in several minutes. We don't need quorum now, we need quorum during votings, and in the end, the last 15 minutes we'll have common sitting with Liebe and which Econ together, so then we will have to check it again. First of all, I have a pleasure to replace our dear chairman. I hope it will be smoothly done. We will see. So, first of all, adoption of agenda. Dear colleagues, I submit to you the following changes to the draft agenda. First of all, the item 10A was added. Vote on Libe Committee following ID groups. Request to challenge the coordinated decision on point 6.2. Welcome, this Commissioner. I have to read now the procedure on which I'm starting with the agenda. So once again, the item 10A was added. Vote on Libe Committee following ID group's request to challenge the coordinated decision on point 6.5.2 of the final feedback note of the coordinators meeting of September 6, 2022. And the Libe meeting was shortened by that I announced before, because in the end we will have the common sitting with Econ together to adopt one of the points. Then I would like to announce that interpretation today will be in German, English, French, Italian, Dutch, Danish, Greek, Spanish, Portuguese, Swedish, Czech, Estonian, Hungarian, Polish, Romanian and Bulgarians. Speakers are invited to speak their mother tongue if it is one of the languages for which interpretation is available. It is strongly recommended to avoid reading out of a speech. Please use your speaking notes as a background material and speak freely and at a natural pace. I would like to thank interpreters in advance for the cooperation. Endorsement of coordinators' recommendation pursuant to Rule 214. You will find in the meeting documents, 3 of them, the outcome of the written procedure of 1st September 2022, the feedback note of the coordinators meeting of 6th of September 2022, and the outcome of the written procedure of 12th September 2022. Nomination of reporters. We have 5 nominations. So first of all, I would like to announce that Javier Zarjalejos from EPP Group has been nominated as a rapporteur for the Libe report on the proposal for the regulation of the European Parliament and the Council laying down rules to prevent and to combat child sexual abuse. Then Laurent Vince, also from EPP Group, has been nominated as a rapporteur for the Libe report on the proposal for a directive on asset recovery and confiscation. Also from EPP, Paulo Rangel has been nominated as a rapporteur for the Libe report on the draft Council decision on the full application of the provisions of the Schengen acquis in the Republic of Croatia. Then Matthias Nemec from S&D has been nominated as a rapporteur replacing Tanja Fajon for the Libe report on the proposal for a regulation of the European Parliament of the Council on the standards for the qualification of third country nationals or stateless persons as beneficiaries of third country nationals or stateless persons as beneficiaries, once again, I'm sorry, of international protection for uniform status for refugees or for persons eligible for subsidiary protection and for the content of the protection guaranteed by and amending Council Directive. T. Surusten from S&D has been nominated as reporter, replacing Tanya Fayon, again for the LIBE report, on the proposal for a regulation of the European Parliament and of the Council amending regulation number 539 from 2001, listing the third countries whose nationals must be in possession of visas when crossing the external borders and those whose nationals are exempt from that requirements. And we have also one opinion, and then Damien Carême from Greens Group has been nominated as reporter for the LIBE opinion on the report on the ECON INI report on lessons learned from the Pandora Papers and other revelations. Das committee endorsed this coordinator's decision and recommendation pursuant to the rule 214. Then we can move to the next important point. We have to approve of minutes of our meetings, 31st March, the first one, and the second from the 10th of May 2022. And these are all the formal things, I think, done. So we can move to the next point. The point titled Child Sexual Abuse Material, proposal for a regulation of the European Parliament and of the Council laying down rules to prevent and combat child sexual abuse. Dear colleagues, we will now move to the presentation of the proposal for the regulation laying down the rules to prevent and combat child sexual abuse. As you know, in September 2020, the Commission presented a first legislative proposal containing an interim regulation allowing independent interpersonal communication services to derogate on a voluntary basis from the privacy rules contained in a privacy directive to enable them to continue to detect and report child sexual abuse material online. In order to create a set of permanent rules replacing the interim regulation, the Commission published on 11th May 2022 a proposal aiming at obliging providers to detect, report and remove child sexual abuse material on their services. Providers will have to assess and mitigate the risk of misuse of their services, and the measures taken must be proportionate to that risk and subject to abuse conditions of safeguards. The proposal also foresees the creation of a new independent EU Centre on Child Sexual Abuse to facilitate the efforts of service providers by acting as a hub of expertise. In the joint declaration of 17 December 2020, the European Parliament, the Council and the Commission agreed to give the utmost priority to the initiative of combating child sexual abuse online. We have today the honor to welcome Madam Commissioner Ylva Johansson, who will present the main points and main aspects of this proposal. The floor is yours.
Thank you. Thank you very much for this opportunity to come here and present this proposal that I'm very proud of. Can I just start by putting it into context? I think you all know that we're talking about a heinous crime, and a crime with this, unfortunately, it's much, much, much more common than we would like it to be. One of the first proposals I put forward as a new commissioner was the strategy to combat child sexual abuse in the beginning of summer 2020. And that I put forward because this is one of my top priorities. We are now implementing this strategy. Then we had a situation in December 2020 where a new regulation came into place that will stop the voluntary detection that was going on. I will come back to that, but we addressed that with a temporary legislation that's been adopted, and now I'm presenting a permanent legislation which deals with the online component of this crime, but also on the new EU center that I'm proposing. And then now I am preparing to revise the Child Sexual Abuse Directive. And that will come, hopefully, a proposal next year that will also deal with the scope of, for example, the issue of pedophile handbooks and other areas that will come in the proposal next year. So it's important to see that these are all linked together. The current proposal addresses the online component. And just to remind you where we are today. Since more than 10 years, companies have been voluntarily detecting child sexual abuse material and grooming online. They can do that, have been able to do that voluntarily. There have been no restriction really on how to do that as long as they comply with the GDPR. In US, they are obliged to report what they found when they do detection. So that means that's the reason why we now receive a lot of reports via the American NCMEC organization. It's about 4 million videos and pictures that's being reported that are coming from the EU or being sent to the EU in the EU jurisdiction. Last year it was fewer because of the we were waiting for the temporary legislation to come into place, but 4 million, I should say, is the number of videos and films, videos and photos that have been sent on the EU. With the temporary legislation that is now in place, companies can continue voluntarily do the detection with some additional privacy safeguard. That, for example, they have to consult data protection authorities for some of the technology that they use. This legislation will run out of time in summer 2024. After that, there will be no possibility at all for internet companies to detect any of those pictures, videos, grooming in any private communication after summer 2024, if we do not adopt a new legislation. So this is the legislation I'm presenting now, and that will replace. I think what we have done in this new legislation, we have learned lessons, and we have listened from, especially learned lessons from the debate we had on the temporary legislation. So this new one will make it much more restricted for companies to do detection in communication if you compare with the current situation. Much more restricted. We have put in additional safeguards. I will come to that. So that is one big difference. If we compare the situation today, what companies are allowed to do in private communication, with the new proposal, it's much, much more restricted what is possible to do. Second, we have focused even much more on prevention. This is important. So what we put in place in the new legislation is mandatory for companies to work on prevention, to do risk assessments, and to take mitigating measures to prevent children from being groomed or child sexual abuse material to being sent using their services or hosted in their services. So this is also a big shift. Another shift is that we make it mandatory. We say you're much, much more restricted on what you're allowed to do. But if you're allowed to do it, you're also obliged to do it. So you can't say that some companies will do the detection and some will not. So if they are coming to a situation where it's not enough with the preventive measures and there is the companies being allowed to do detection in a communication, they should also be obliged to do it and to report it. We are also strengthening the way when it comes to the technology. So companies, in my proposal, can only use hash technology or classifiers that have been approved by the EU center that I propose that we should set up. So this is another additional safeguard that we put in, that they have to use the technology that's been approved by the center. We also have a situation of a lot of reports being sent to law enforcement, and some of these reports are not of good quality. So this we also address with the proposal, so that only those reports that are really validated to be significant or on child sexual abuse material and that can be investigated. These will be sent to law enforcement so that they can focus on those cases that are their possibilities to actually go after the perpetrator and rescue children. What we also have in this proposal is additional legislation to force companies to take down materials. I met this morning with a father, Marcel Jeninga. His daughter was being sexually abused since she was born until she was 3 years old. She's now 15 years old. And the pictures of this little girl being tied in ropes and being abused is still online. It's still online. We need to strengthen the legislation to really get rid of the material that has been found online. So these are the changes that I would make if you compare to the current situation with the new legislation. And on the privacy safeguards, and I know that's a big concern for many of you, and you know the situation is that in the EU legislation, it's only possible to do the detection in privacy communication and in encrypted communication. You can only do it, it's only legal if you do it to go after malware. And if we don't put any legislation in place, all detection of child sexual abuse will be illegal after summer 2024, and only detection of malware will go on. What we have put in place is to try to be technology neutral in the legislation, because we see how quick technology is developing. We put an important role for the center to evaluate technology. But we also know that these perpetrators, they will develop new ways. They instruct each other also how to find new ways to reach out to children or to exchange their material between each other. So we have to have a legislation that takes that into account. That's why in my legislation I propose that all companies should be obliged to do the risk assessment, should be obliged to take mitigating measures to deal with the risks, and then report that to the National Coordinating Authority. The National Coordinating Authority can then ask for additional mitigating measures if they don't think they are doing enough to protect children or to avoid material to be exchanged on their services. If that is not enough, the National Coordinating Authority can propose that they also should do detection. Before they make any such proposal, they have to consult with the Data Protection Authority, with the companies, of course, and with the new EU center. But it's not the National Coordinating Authority that takes the decision. This proposal on detection under specific circumstances has to go to a national independent, it's usually a court, but it's not necessary, but I think in most member states it will be a court. And this court will do the assessment whether this is a proportionate way, and if the safeguards and the time limits, because there always have to be a time limit for how long the detection can go on, and how the reporting should be in this specific case. And only after it's been approved by that court, a company are allowed to do the detection, but then they're also obliged to do it. So that's why we try to use to set up the right processes so that at each time also make the balance whether if it's privacy intrusive, it has really to be seen what have been done to mitigate the intrusiveness, and is it effective, of course. So you are not doing something that is not really effective towards the task that you need to deliver on. With my new proposal, we will have the GDPR as a basis. We will have the DSA and the e-privacy. And then on top of that, so to say, we have this child sexual abuse material legislation. Thank you.
Thank you very much. I will now open the questions and answers session. So let's organize in that way that you will have 2 minutes for the question, and then I will give back the floor to Madam Commissioner for her reply. I have not full list of all the groups, so okay. Once again, Mr. Sarsalejos will start from EPP.
Thank you, Chair. Thank you, Madam Commissioner. Thank you for your presentation, and thank you also for your personal commitment to this issue and to make it a priority. I would start by saying that, to be frank, would have liked to have this proposal earlier. It is a complex file that will take quite a lot of time and discussion to have done. And I'm sure it will continue the ongoing debate not only in this Parliament but in society at large about the trade-offs between privacy and security, the kind of technologies available, the impact of these technologies, and the best regulatory approach. The issue of CSAM is a major challenge. You have given us some inputs about that. It's a challenge for law enforcement. It's a challenge for civil society organizations. It's a challenge for parents and teachers, and also a major challenge for us as legislators. This situation is also evolving, as you mentioned, because for example, we see an increase in explicit material self-generated by children. We see an increase in grooming. Well, all this makes our task probably more difficult, but at the same time more necessary. In my opinion, there are 4 main areas on which our discussion should be focused, and I will propose that as a rapporteur. Apart from, obviously, the scope, first is the choice of technologies to be applied to different types of CSAM. The safeguards, both substantive and procedural, the procedure leading to a detection order, which is something very, very, very important, and also the setting up of the European Centre. As you said, Madam Commissioner, some of these items are not new to us. We discussed them extensively and thoroughly, and I'm sure that this previous discussion will be extremely useful for the purpose of this proposal. It is true that things are changing. Now we see the extension of encryption in services provided by internet companies, while better protecting privacy and the integrity of communication. It also raises some issues as far as law enforcement and detection is concerned. I particularly welcome the setting up of a European Centre of Child Sexual Abuse. There are a few issues to clarify regarding the functioning of the centre, but there is no doubt that it will become a key instrument in the fight against CSAM and will render the efforts by law enforcement, civil society organizations, industry more efficient in achieving this aim. Now, Madam Commissioner, let me touch upon a couple of issues that I would like to have your opinion about. First, about the possible gap between the coming into force of the regulation and the detection order that will take some time to be decided, and the sunset clause affecting the interim regulation. And on the other hand, as you said, first there will be mitigation measures taken by the companies. If they are not enough, they will have also will be imposed a detection order specifically on their services. I'd like to ask what kind of voluntary measures the companies will be entitled to take. Are there the existing ones or are different? And the second is about encryption. I would like to see your approach on that, how serious it is just a matter for judges to decide, or what is your approach? And having said that, I do look forward to work together with my colleagues, other rapporteurs in this file. Thank you.
Thank you very much. I don't like to be unpolite and to interrupt, but please, I would like to ask you for the discipline, if 2 minutes, not to prolong this 2 minutes.
Thank you for your generosity,
May I
Chair.
take the questions? The floor is yours, Madam Chairman.
Thank you for the questions. So first, there is a risk of a gap. It depends on how quick the new legislation can be adopted. The situation is, at the moment the temporary legislation run out, it will be totally forbidden for any detection in communication for child sexual abuse material in the European Union. Because we have the strongest privacy legislation in the world, that means if there is not a specific law that allows under specific circumstances, then it's forbidden. So that, of course, it depends on the timing, but there is, of course, a huge risk of a gap here, depending on the timing. And voluntary measures will also be forbidden. All detection that is now going on, all that's been done, I mean, if you have children that play on Roblox, for example, you know that they have tools to avoid the grooming to take place in the chat. That will stop in the European Union if we don't have a new legislation in place. And I think that's right. I mean, we should have strong safeguards on privacy, and it should only be allowed when there is a specific legislation that allows it. And this is the one I have put on your table. And it's possible to have it adopted in time, I think, before summer 2024. But this is the reality. The detection is going on right now and has been going on for more than 10 years. On the encryption, so today we don't know whether companies are actually detecting child sexual abuse in encrypted communication or not. They could do, but we don't really know. We know that they do it in encrypted communication when it comes to malware. Most of them do. And that's what we can see, I mean, when we are using this communication. Now, if I text you on WhatsApp, for example, it's end-to-end encrypted, and I will send you a page of a newspaper. When I have written half the name of the line, it will pop up, yeah, as a picture, because they detect it, yeah, and they make sure it's not malware. So they are doing detection in encrypted communication today. But whether they do it today for child sexual abuse, I can't answer.
Thank you very much. Mr. Tang from S&D is the next one. Next question, 2 minutes.
Thank you, Chair, and welcome, Commissioner. And thank you also for making this your first priority, to have this strategy against the fight against child sexual abuse and the dissemination of the material. That is very much appreciated. And I think we welcome that you take this initiative and that this is your first priority. I think we're all united, what you call, in our fight against the hideous crimes. And in this fight, we need to work together to come to a common approach. I remember that I organized a workshop on this where you were present with Evan Anschier, and one of the marks you already have made when it will be a lasting heritage will be the EU Centre, because everyone is looking forward to that, where we can cooperate to find an effective approach. Of course, we need to find a proper balance between fighting CSAM and limiting fundamental rights. That's a difficult challenge for all of us. And this is what S&D will try to do. Now, I have some questions for you in view of the time, Chair, and I will try to stick to the 2 minutes. Are there any limits to the detection orders? Still not very many. Could it mean that such detection orders entail an obligation to decrypt communication? Does it violate end-to-end encryption? Do you see a risk of general monitoring, which is forbidding the e-commerce directive and the Digital Services Act? And in prepping this meeting, I was a bit surprised to see also that the big tech, which I don't consider my friends, are really cautious in this sense. For example, there's an advice for Facebook by company BSR that says deployment of client-side scanning technologies as they exist today should not be pursued, as doing so would undermine the integrity of end-to-end encryption and disproportionately restrict people's privacy and a range of other human rights. This is a report by Facebook, right? Have you been in touch with them, and can you respond to this proposition from that side?
Thank you, and 2 minutes for reply, if it is possible.
Yes, thank you for the question. First, in the proposal and in the legislation, we do not address encryption. This is not a proposal about encryption. This is a proposal about fighting child sexual abuse online. This is what it's about. So it's not mentioned. And I think it's really important that we do not exclude any technology. So that's why we do not exclude any technology, but we put in place the safeguard to make sure that we should not do something, should not be allowed to be too much privacy intrusive compared to what is actually necessary for the things to be done. And I know there are been some rumors that companies can be forced to do things that is not technically possible. No, that's not. If there is no technology solution that can find to meet the requirements, then there can be no detection order. So the detection order has to be based on the technology that exists and that you can evaluate, and then you can see whether it's enough, if it's the right one to use. And it can only be used if it's compliant with GDPR. And they can only use the hashes and the classifiers that's been approved by the center. And they also have this consultancy with the data protection authorities in advance. And there is a specific time limit for a detection order. It's quite short, I should say. And then it's necessary to have a new decision. So this is, I think we put the safeguards in there. And the detection that goes on right now in encrypted communication, I mean, I do not consider that being that encryption is broken, but because they do this detection. So I can't really see that this could happen. And when it comes to Meta and Facebook, it's interesting. I have several discussions with them. They are very much against my proposal. Let's be clear. They don't want to be regulated. They don't want to do this. We have really tried to convince them many times. They don't like this. They are actually moving away from some of the detection that they have been doing. What they argue for is to use metadata. And I should say this is privacy intrusive and not efficient. So using things that will intrude the privacy, that will actually not really find the right materials, I think it should not be legal to do that. So we have always to have the balance that if it's part of privacy intrusive, it has really to be that it works for the aim that is actually that we are after, to go after the perpetrators, to rescue children, and to stop this material of being spread. Otherwise, we should not allow them to do that. But I know they are campaigning against it, and I went there, I met them several times. No, I have not convinced them. That's for sure.
Thank you very much. Now we can move to Renew Group. Well, I have two names, because, Madame Votmans was first, but Sophie Infeld is also registered, so you can decide. Yeah, I have the third name too. Madame Votmans, floor is yours.
Thank you very much. And dear Commissioner, you know, we met already. I really would like to thank you for this proposal. Since the Commission proposed the regulation, I've had meetings with several stakeholders. And what is clear is that they all support the idea of unified rules, the aim of the legislation, and the need for a correct balance, like we already hear also, between privacy of adults and, of course, the protections of the rights of the child. However, the stakeholders also raised several concerns, and I would like to ask them here to you. First of all, what will be the role of the hotlines? I think that's a question that came up several times. Second, in terms of prevention, how does the proposal tackle the demand for images and exploitation? Third, most remarks concern the complex and lengthy procedures. How can we streamline the proposed procedures? Should it not be, that's something that I feel, the techno companies reports to the EU Centre, the EU Centre then filters, illegal reports will go to the law enforcement, and involvement of an independent judge before orders can be sent. The authority should only control the implementation of the legislation and help with the risk assessments. How do you think about this? Because I think it's really a long, difficult procedure. Finally, the EU Centre, that's also a question that many of them pose to me. Who would staff it? Who will be in that EU Centre? And last, how do we solve the issues in connection with the US, where companies are obliged to report, and in principle, they cannot report to another organization. So do we have to meet, do we have to make an agreement with the US? Thank you very much, and you have our support on this legislation.
Thank you, Madam Chairman.
Yes, thank you for these questions. First, the role of the hotline, they are extremely important, and we need to continue working with them. Their role will not be changed at all, but their role will be enforced. Why? Because with the new legislation, they can have the EU legislation to force companies to take down the material. If it's outside the EU jurisdiction, they can force companies to block it. So it's not accessible from the EU. So that is what we can do. And that makes we give more power to the hotlines in that aspect. Yeah, the prevention is really the key thing. We are now implementing the strategy that I presented in 2020. That, for example, that we are financing also the research on prevention. I also visit some of those researchers and discuss with them, and things are actually moving forward here. We are also going after member states on the implementation of the current directive, where prevention is really an area where they need to do more, and they are doing more. So this is good because they are complying now to a larger extent while we are working on this strategy to make sure that they implement it. And then prevention will be a big part in this proposal as well. Maybe I don't understood your question rightly, but the EU Centre will do the filtering. So the EU Centre will make sure that only the real reports really go to law enforcement, so that the quality reports that they can work on. Another important thing is that if there are false positives that are being sent to the centre, they can give the feedback to companies that maybe they are detecting in the wrong way because they got false positive. Today, there is no such feedback because everything is being reported. So I think this will also help with fine-tuning the tools that are being used. The EU Centre will be an EU agency, and they will run under the same regulation as other EU agencies when it comes to an independent management board, executive director, staffing, and so on. And yes, we need to find a technology solution for the reporting so that companies do not double report. And we have only been discussing with NECMEC about this, so that I think is not a big thing actually to solve. But of course, it has to be solved.
Thank you very much. And Mr. Breyer is the next speaker representing Greens.
Dear Chair, dear colleagues, Commissioner. Commissioner claims to speak on behalf of children and victims of child sexual abuse. But what a survivor, Alexander Hanf, just posted is, and I quote, "I broke down in tears speaking at the European Parliament about my abuse and why this law will only serve to harm survivors and victims of sexual abuse. This proposal will make it more difficult for millions of children to seek support, tell their stories, and secure justice." If the Commission really intended to curb the circulation of this abhorrent material, why does their proposal fail to oblige Europol and national law enforcement authorities to report known material to providers for immediate removal? I'm appalled that millions of images and videos are knowingly allowed to stay online by Europol and other agencies, as Europol has confirmed to me in writing. And colleagues, these days we are experiencing a global conflict of authoritarianism versus democracy, and the Commission is proposing a mandatory general monitoring scheme so extreme that it does not exist anywhere else in the free world. Not in the US. The US does not have mandatory detection. Not in Canada, not in the UK, nowhere else in the free world. The only country practicing such indiscriminate searches is authoritarian China. And colleagues, as a democracy, we need to stand up to our values to win this struggle of systems. My questions to the Commissioner are, firstly, is it true, Commissioner, that for your claims on the accuracy of the scanner algorithms, you rely exclusively on manufacturer claims without any independent review? And secondly, your proposal has prompted the European Data Protection Board, the European Data Protection Supervisor, to warn that the proposal may present more risks to individuals and to society at large than to the criminals pursued for, and that there is a risk that the proposal could become the basis for a generalized and indiscriminate scanning of content, and that the proposed detection orders may in fact even harm those they seek to protect. So based on such damning criticism from the institutions tasked with protecting our fundamental rights, how are you helping children by proposing a regulation that will invariably fail in the European Court of Justice for violating fundamental rights? If this proposal is adopted and then annulled later down the line by the court, we will have wasted years that we could have worked on more effective and proportionate solutions to protect the victims of sexual violence. Why not start this work right away now?
Thank you. It's time for answer.
Yes, thank you. Let me first say, the detection is going on now. It's been going on for 10 years and even more. And I know this, I hear this fear that with the new legislation that will restrict the possibility to detect compared to the current situation, children will not be allowed to send or to contact somebody that could help them or a lawyer. If that was the case, that should be the case right now, because right now the detection is ongoing. And we have some more restrictions in the temporary legislation that is in place now, but the new one will have much more restrictions than the current one. So this is actually totally false to say that with the new legislation there will be new possibilities of detection in communication that doesn't exist today. No, there will not be. But there will be the possibility, let me answer the question, but there will be the possibility to force companies to do some detection. And I think that's right, because I don't think we should rely on companies' goodwill to fight child sexual abuse. But the technology to be used is it's more free today than it will be with my new proposal. Then may I also say that, for example, the Fundamental Rights Agency has also looked into this proposal, and I think they have been very clear. They say it's not infringing the fundamental rights. There is a possibility to do this kind of legislation, and it's justified by the fundamental rights. Where is the exact right balance to find is, of course, for the legislators to find this right balance, and that is what we need politicians for. That's what we do in the real world, and that's what we should do on the online world. And that will, of course, lead to that some political groups or some stakeholders will have diverging positions. That's normal in a democracy. But then we should find a conclusion where we can agree and find a big support for the legislation that finds the right balance on this proposal.
Thank you. Now we can move to ID Group. Madame Daisy. Yeah? Is here. Yeah? But Madam Assista Kanko is not in the room. So the left, Madame Daisy, the floor is yours.
Thanks very much, Chair, and thanks to the Commissioner for coming in. I'm not the shadow on this. I'm speaking for our shadow, Cornelia Ernst, who can't be here, and I was listening to the Commissioner's replies, but I have to say I know Connie had shared an awful lot of the concerns that Patrick has, and I'm not fully sure that they've been answered, but her concern is that the proposal will result in a generalised automated scanning of everyone's private communications basically all of the time, and is a massive and disproportionate interference with people's right to privacy. And for us, I suppose, whether for detecting child sexual abuse material or other purposes, massive indiscriminate intrusion on people's privacy is never justifiable in a democratic society, even for the most horrific crimes. And we would question the illegality on that basis, and also the proportionality in terms of a response to crime, because it obviously doesn't prevent crime, it doesn't even help to find it. And I suppose the concern would be that it opens the door then for a sort of a mass surveillance, because what will be done in this crime will certainly be extended to others later on. So just maybe a couple of quick points on it. And again, I'd like to hear more on the concerns of the experts that the proposal lacks a sufficient legal basis. I'd like a little bit more reassurance or comment on that. I mean, I noted what you said about FRA, but many stakeholders underline that the proposal fails to meet key human rights principles of necessity and proportionality, and in that sense violates fundamental rights. So I think your own regulatory scrutiny board even said that the proposal may violate the prohibition of general monitoring. I'd like a comment on that. It seemed strange. And then just in terms of the scanning and so on, and the algorithms used on that, and the idea of false positives and all the rest, I mean, where is that at? Because, I mean, if you're talking about, say, a scan of 1 million, how many thousands are going to be caught up in that and referred potentially to law enforcement authorities for the heinous crime of child sexual abuse? I mean, you prefer to be, referred for murder probably than that. So it is pretty serious allegation in that sense, and I'm wondering where that's at. Are you just relying on the manufacturers, or what's the basis of the algorithm and the effectiveness in terms of false positives and so on?
Thank you, Madam Daly, and the reply. The floor is yours.
First, on the accuracy of the tools that are being used by companies right now, they are quite good, I should say. On the known content is 1 false out of 50 billion. In others, I think it's 0.1% of some of these not already hashed content. And these are technologies that are improving all the time. But I think it's important that we say that the kind of hashes and these, what is called, the qualifiers, classifiers that they could use should only be the ones that have been approved by the EU Centre. So it's not like it is today, that companies can choose what kind of hash technology they use. They should only be able to use the ones that we have provide via the EU Centre. Then on the legal basis is based on the internal market. But what we see today is that member states are dealing with this problem on different ways in different member states, and that really risks to hamper the functioning of the digital single market. And that's why we need a common EU approach on this. Can I also say that preventing crime is really the most important way, and that's why prevention is the core in my proposal. And that's why I also started to say this is not the only initiative I take in this area. I have already taken other initiatives with the strategy. I'm planning to revise also the directive. We are setting up a new center that will also play an important role when it comes to both support victims and do the prevention. So, of course, the online component is not the only problem here, but this is what is in the focus in this proposal.
Thank you very much. And last in the first round, Mr. Ulrich. The floor is yours.
Thank you, Chair. First of all, I would like to complain that I see there is no Slovak translation. I think it's not okay. We should always ask for it, because it should be done by default, and our citizens cannot follow this meeting. Otherwise, they don't have a right to ask for the translation. But to the point. I think measures to combat child sexual abuse online are, of course, necessary, but as my colleague said, it shouldn't be abused for introducing a general monitoring tools. But my question is, what about promoting pedophilia online? For example, in Slovakia we have a liberal newspaper called SME, it's quite common, and they are defending pedophiles themselves. For example, they are said that pedophiles are not criminals in one article. In another article, that we as a public citizens, we condemn pedophiles unjustly, and public opinion is against, and the public opinion against pedophiles is not justified. Another article, which is quite extreme, that even pedophiles have right to live without prejudice, and this is still online, written by the deputy chief officer. So, is it okay to allow spreading such things online? I think we should stand against pedophilia and not allow to normalize it, to become it something normal, like nothing has happened. If somebody is a pedophile, we should always say that this is not good, this is wrong, and the person who does it should be criminalized. So my question is whether your legislation, Madam Commissioner, does cover also this propaganda or promotion of pedophilia. Thank you.
As I said in the beginning, this proposal that we're discussing today only addressed the online component. We are working on, and we'll soon start impact assessments for the revision of the Child Sexual Abuse Directive that will also deal with the scope and other issues.
Thank you very much. I've noticed also your remark on the very beginning of your question, but I understand that it's also possible translation under the passive mode. So it was mentioned in the document written. Well, I have 3 additional names in the list. I would like to organize the second 5. Oh. Because we have a very long list of points, but not to eliminate anyone. Maybe the proposal will be to gather all the questions in 1 minute from all of you, and then the answer for all these questions. So, starting with the first registered, Mrs. Sippel.
Thank you. Commissioner, you started your introduction by talking about one of the most unacceptable crimes, and I think we all agree. Nevertheless, I don't agree why the legal basis is internal market. I fully agree we should have harmonized rules here, but harmonized rules should also be there when it comes to criminal law. So I still fight a little bit with this legal basis of the internal market. Regarding the question of prevention, in the text, prevention is mainly mentioned when we talk about detection of all kinds of communication. I don't see anything how we strengthen and empower children and young people how to behave in this digital world and how to say no to potential people and also to talk about things they believe are a little bit scary, unacceptable. So I don't see anything about that, but I think that's very much needed, like in the real world, because in the last years we saw again and again child sexual abuse of the same children over years, and children were never talking about. So something is wrong right here, and we have to put something into even in this proposal. Then talking about the center, I think some people already asked for it. I haven't heard a concrete answer. Who will be the experts in that center? So is it only police? Is it child protecting officials? Is it people having expertise in dealing with victims? So what precisely is it? How do we put it together? And then when talking about data protection, let's be honest, also children, and children more than everybody else, have a right to data protection and privacy. And I wonder if we try to go into communication for preventing abuse, it's very, very easy and foreseeable that even communications between peers, 16, 17 years old, is flagged up. How do we deal with that? And the final question is, why is it, if I understand the text correctly, that the providers can take a decision, this is illegal, and then can immediately delete something? How can this happen, and what will be the consequences of that? Thank you.
Thank you. From the Renew Group, I have 2 names, so let's give a chance to both. Sophie Infeld first, and then Mr. Reuten. But 1 minute, please.
Thank you, Chair, and thank you, Commissioner. My skepticism about the law is well known. I voted for the emergency law, but with a heavy heart. And that brings me to my first question. You gave a fairly horrifying example of material that is still online. I wonder, and then you said that we need new legislation to take it down. But as far as I know, what you've described is simply a crime and should be taken down, you know, whether we have this law or not. So it means that the interim law that we adopted doesn't work. My second point is, I'm sure that over summer you heard about this example of a father in the US who during the COVID lockdown sent a picture of his toddler, 1.5-year-old or something, who had an inflammation on his genitalia. He sent it to the doctor because he couldn't go there because of the lockdown. And what do you know, next thing, he is labeled a child abuser. He was cleared by the authorities, but not by Google. Google refuses until the day of today. So how are you going to prevent, and there are more cases like this, how are you going to prevent that? Third issue, you are talking about the hashes. The hashes are not the problem. It's not so much about detecting known material. It's about algorithms, not about hashes. That is where the biggest problem lies. And my biggest problem of all, Madam Commissioner, is enforcement. Because I've been around for long enough to know that the Commission does not enforce EU law at all. Not at all. I'm currently in the, like my colleague here, in the inquiry committee into spyware. There is a whole range of EU laws which exist, but they're simply not being enforced. Why? Because the European Commission, and I'm not addressing you personally, but your institution, is just too afraid of the member states. That is the real problem. And people go to court to complain, and the ECJ or the court in Strasbourg sort of says that they are right, and still the Commission doesn't intervene. This is my problem. What are the safeguards worth if we cannot trust the Commission to enforce? And there I have a big problem with trust in the Commission.
Thank you very much. And the next question, Mr. Otin.
Thank you, Chair. Madam Commissioner, I try to stick to 1 minute. Madam Commissioner, you said, well, one might have different political views on the issue, but at the end, you strike the right balance, and it's a question of political will or matter. Well, politics do not work like this. I mean, there are criteria that we have to use, and the criteria of proportionality is clearly one where I think that has not been respected when you proposed this legislation. Are you aware of the legal opinion from a former judge of the European Court of Justice finding that indiscriminate researches of private communication do not comply with case law, including the court's La Quadrature judgment? And I was a former member of parliament before having been elected to the European Parliament in Germany. And what I learned always is that there are legal services that tell us what we're able to do or not, and what we should do or not, what is complying to case law and to constitutions, etc. And the German Bundestag legal assessment is that the permanent latent risk that a crime, even of a serious nature, may be committed should not suffice to justify continuous and comprehensive automated analysis. And that's what you are proposing. I don't think that this stands before the European Court of Justice.
Thank you very much. Mrs. Bridgman, the floor is yours.
Thank you very much. I think this second round of questions makes it clear about our main concerns, and I wanted to quote the UN High Commissioner for Human Rights in his report, The Rights to Privacy in a Digital Age, that encryption provides women who face particular threat of surveillance, harassment, violence online an important level of protection against involuntary disclosure of information. I think we all know that it's impossible to analyze the contents of end-to-end encryption communications, that service providers would have no choice, actually, but to undermine encryption with backdoors or client-side scanning in order to comply with a detection order. Does it mean that the European Commission is ready to sacrifice privacy and safety of women, but also of children who rely on encryption? And is this compatible at all with the Charter? This is my first question. And I quickly have a second question. Can you confirm that, at least in the directive or in another text you're referring to, that adequate capacity of law enforcement agencies and that the strengthening of responsible investigative units in terms of personal and funding and financial resources to ensure long-term, thorough and sustained investigations, but also preventing such recordings to happen in the first place. So the real focus on prevention schemes and also training, etc., will be addressed by other texts, by the directive. And I linked it to what you said about the role of the National Coordinating Authority. Will this be mandatory, which means will be affected to this? Will the member states have the obligation to put such a reference into place? And is it not one more layer, considering the current needs for investigation, human resources that are already what is lacking in the member states in order to implement the existing legislation?
Thank you very much. And Mr. Kolaya, as a last speaker, 1 minute for question.
Thank you very much. First of all, I fully support protecting children, and as well as my political group. The question is how, and for the how we need to understand the problem. So, according to the Commission's impact assessment, there's 1,630 companies registered to report to NECMAC. Now, of these companies, Facebook sent 95% of reports, and according to Facebook's own assessment, from October and November 2020, the company found that more than 90% of the reported content was the same or visually similar to previously reported content. And copies of just 6 videos were responsible for more than half of the child exploitative content reported. So now the question is, does the Commission have any idea on how many children fell victim of abuse in these reports in Europe, and how many cases of abuse were followed up by police investigation? And how does the Commission plan to incentivize member states to fully implement the 2011 directive on combating the sexual abuse and sexual exploitation of children, especially the articles regarding the assistance and support of support to actual victims? Thank you.
Thank you very much, and I would like to ask you for all the answer for the question.
I will try. First, well, the same day as I presented this proposal, the Commission also presented a proposal for better internet for children. So we are addressing the safety of children not only here, but also in this proposal that my colleague Dubravka Suica was responsible for. We had actually the press conference together with these 2 proposals because I think they go well together. There will be experts in the center. There will not be, the center will not be a police. This will be an expert center that will gather best expertise and to provide support to member states, but also expertise support towards companies and work together with civil society. But it will not be mixed. They have no, it's not a law enforcement agency that we are creating. On the interim legislation that is in place, we say that companies are allowed to detect, and if they detect, they should also remove. But in the interim legislation, there is no obligation for companies to actually take down if you reach out and say you have to take down because this is my child or this is me, and that's why we need this EU-wide legislation on this, and that's why I propose it. In the role of this center will not only be to validate the hashes, but also the classifiers. And the classifiers are those that have been used for the new material and grooming. So that would also be the role for the center to validate what kind of classifiers should be able to use. It will not only be the Commission, but also be the coordinating authorities that will oversee how this is being implemented by the companies. And there's also the national coordinating authorities that will be able to fine companies if they do not comply with the legislation. And I didn't say that, of course, I think that I have found the right balance between protecting children's privacy and also protecting others' privacy. But I'm sure that the co-legislators together will find the right balance. And that is how we should do it, and that is how we do it in all other areas that we discuss. We have a debate, we might have diverging views, and then we find a way forward that is hopefully the right balance. And we are complying with the charter, and the police will be able to achieve the files, the reports that have been filtered. Facebook are not filtered at all. They send everything to NECMEC. Other companies filter themselves before sending it, so that it's the reason why the numbers of reports from Facebook is so huge, because they have no internal filter before they send it, and others have. And of course, now with the new EU center, they will do the filtering before sending it to the police. Also, so the police will not be overwhelmed because they will have more filtered reports. And I don't have the figures with me, how many cases on children that have been rescued, but we know that those that have been reported to Europol, we know what cases there have been and how many children have been rescued. And we can also say that in some member states, these reports that they receive via NECMEC today is 80% of the investigations are based on these reports. And very often it is like this. They have a report of child sexual abuse material. When they go into, it might be known material that is been duplicated. When they go into that computer and investigate, then they find out very often, in US, on 50% of the cases, that this person is also not only doing the illegal thing to watch these videos and films, but also reaching out and doing the sexual abuse ongoing in the real world. That is the figures from the US. So there is very often that kind of link. And on the 2011 directive, that's what I said in the beginning. I said in the strategy that I presented more than 2 years ago that we will go after member states to make sure that they fully implement the current directive. And this is what they have been doing since then. And it's actually, we see a lot of progress, so we can stop some of these infringement procedures with member states because they comply. So this is extremely important, and that was in the strategy I presented more than 2 years ago, and now is what we are working on.
Thank you very much for the presentation and all the answers to our questions. Let us proceed to our next point, next item, which is number 5. Automated data exchange for police cooperation, PRIM 2. Our rapporteur is Paulo Rangel. Paulo Rangel will present his draft report on the item, but not prolonging the introduction, I would like to emphasize one important thing. The deadline for amendments for this file will be on Friday, 21st of October at midday, 12 o'clock. So, Mr. Rangel, the floor is yours. 5 minutes, is it enough?
Okay, thank you very much. I hope that I don't need to use all the time. And in order to fulfill this requirement of being quite brief, I will change to my mother language.
We find ourselves here looking at changes to the way police data is exchanged within the Schengen justice area. And the justice area being even larger than Schengen. So we talk about this PRIM 2 legislation, and it's a second phase of police cooperation and data exchange. And this is something that we need more badly now than ever before, because we know that a large percentage of criminal organizations are working across several member states. So this legislation seeks basically to put together a new wave of make a new wave of information exchange possible. Information relating to crimes, cross-border crimes, and becoming more sophisticated in the way we do this. And in turn, more efficient as well. So we feel the Commission proposal, when it comes to data exchange across different public authorities and Europol, is going to lead to a more semi-automated PRUM system and databases. And obviously, this must all be done in full respect of national legislation and national regulation. And this will then enable the exchange of information under the PRUM system. Now, PRUM 2 could then be used to support search operations for disappeared persons, or to find and identify human remains, for example. And this is so there are potential further extensions of the use of this infrastructure. Now, one point I'd like to make is that we've had a number of meetings, and we've looked at some of the research that's been carried out by experts in this field. And resulting from our assessment of that, we can say that the new PRUM 2 system will indeed respect human rights and will resist manipulation, will also avoid the generation of false positives. So we must insist that the data is anonymized. So that is to say that data cannot be related to an individual person without accessing further data. Second point, results and hits can only be given when they relate to a specific stated aim for a specific investigation into a criminal act. And there must be human interaction, human action involved in this process, and there must be exchange of correspondence between the states concerned, the member states concerned, and a human agent must be involved at that stage. And the competent authorities must keep their data up to date. And this revised regulation is going to ensure that there's adequate data protection, and that the national data protection authorities can guarantee this. So when it comes to the police registers, the police databases, participation should be voluntary, but we feel that those requests should only be honoured in the case of serious crime. And we will be tabling amendments along those lines on behalf of the committee. So that's what we can say at this point about the report, and I'm very eager to hear comments from colleagues.
Thank you very much. Perfect. Now I will pass the floor to the shadow rapporteurs, but I've seen that there is no... But I have the other one. Oh, okay, Paul Tank. Yes, Paul Tank is the first one from S&D Group.
Thank you, Chair, and thank you, Paula, for presenting your draft report. And it's good that we had several meetings to dive deep into this in this topic. May not be always publicly very visible file, but I think it's of high importance indeed. And it's good that we had this exchange to dive deep and to have a better understanding. And of course, it's pretty obvious that fighting for crime fighting purposes, the data exchange in itself is very helpful. However, we must also be aware that more data is helpful to a certain extent. We should strike a balance, again, a proper balance between restricting fundamental rights and fighting crime. And allow me, if you have time, to shortly express three concerns and questions in this regard. The Council proposes to add driving license to the scope of this law, even though it's used at all, and the Commission had good reasons not to put it forward. I didn't see you take position on that, Paula, but I would love to hear that. Second, we need to implement strong safeguards to prevent misuse of this system. These are very sensitive data, and I believe one of those safeguards should be disabling access to the PRUM system if a member state misuses the system. I'm afraid that's not unthinkable. And thirdly, we need more safeguards to prevent phishing expeditions and to prevent data leakages. Thank you very much. And Chair, I need to run to, since we're a bit late, I need to run 2 floors up to another meeting. My apologies for that.
Thank you very much. Is anybody from Renew Group who would like to take a floor? Sophie Infeld, the floor is yours.
Yes, thank you, Chair. Actually, our shadow is Fabienne Keller, but she couldn't be here, so she asked me to read out a short statement. She apologizes for not being present. And she says, I welcome the draft report from the rapporteur. The revision of the regulation on automated data exchange for police cooperation is an important piece of legislation in the framework of the Security Union of the EU. The draft report contains a number of good clarifications compared to the Commission's proposal. On behalf of my group, Renew Europe, we will put great attention to the issue of data protection, including the storage of data between the Member States. Regarding the exchange of facial images, it's also important to address the issue of the quality of the image and the data and the divergences between the Member States. We will make proposals in this direction. I look forward to continue our work on this report. I have one small remark or question, rather, maybe on my own behalf, if I may. And that is, I wonder how this sits with Brexit, because we very painstakingly made an agreement with the Brits, and the continued cooperation is based on an adequacy finding, which I personally believe is inadequate, but they're also changing their data protection laws, and they're also considering pulling out of the European Court for Human Rights. So, I mean, not even the Commission can maintain then that we should continue our PRUM cooperation. So, how do you see that?
Thank you very much. I've seen that we have the next shadow reporters are also absent, so maybe I will ask, is somebody from Greens Group who would like to take a floor? Yes, please.
Thank you very much. I'm not the shadow for the Greens. It's Gwendoline Delbos-Corfield, but she couldn't be present today in the room. So my group really much welcomes and thanks the rapporteur for the draft report. We still have a couple of elements that, of course, we'll work through with the other shadows and through our amendments, but in particular that the automated searching of DNA profiles and facial images should be possible only in the context of individual investigations into serious crimes instead of any criminal offense as provided for in the proposal. This is also one of the remarks highlighted by the EDPS opinion, and we think it's important to mention it. Also, we think that police records is too broad, but the rapporteur already proposes to limit it to suspects and convicted persons, which is a good element. So we are looking forward to work further on the file with you. Thank you.
Thank you very much. I cannot see anybody from ID Group, and also the same situation with ECR. So I would like to ask Claire Daly.
Thanks, Chair, and thanks to Paolo for the work on this. As Paul said, we've had quite a few meetings, a lot of background information, which I think was really useful. I suppose for us, you know, free movement is obviously one of the fundamental and most progressive elements of the EU, but in some ways, unfortunately, it seems like it's being weaponised against citizens to sort of legitimise the need for highly invasive policing and surveillance across Europe, and we would be concerned about that. It sort of feels like that we're smuggling invasive policing and surveillance into member states that wouldn't otherwise get away with implementing them, and it actually might force some member states into implementing them where they would have concerns otherwise. So we don't think that's what the EU should be doing. We would have concerns about the necessity and proportionality tests, which the EU must do in order to intervene in something, even though we had some testimony and good meetings. Still, for us, the data on the actual usefulness of PRUM is open to interpretation in terms of its ability to catch criminals and prevent crime and so on. We're not really convinced that it does make policing more effective, even though some of the contributors thought it did. And we think there's very limited publicly available research being done in this area, I mean, by civil society rather than the EU itself, and found that, you know, less than 10% of Prüm hits were used in criminal proceedings. So therefore we would have concerns in an overall sense, but maybe echo some of the points made by Saskia, and there are issues, I believe, at council level as well in terms of some Danish proposal to restrict this to Schengen members, which obviously would have an impact on Ireland. Now, I wouldn't be that sorry, but I think the Irish government would. But these are issues that we can maybe discuss later on. But just to thank Paolo for the work and looking forward to continuing it.
Thank you very much, and I will pass back the floor to Paolo Rangel, our rapporteur, to replies to our colleagues.
Thank you very much. First I would like to thank the cooperation and I'd say even the goodwill that all the groups have expressed, and in the previous meetings they have already shown. Of course, each one with their own views, as it is normal. Here I should say that on the driving license we have said already that we would follow the Commission, so not to extend this to the driving license in principle, even if now we have been contacted by some associations of people that are lost or that we cannot find, the police cannot find. That would be very grateful if we reconsider this decision, but I'd say that my first assessment is that that would be excluded. Then that, of course, all the searches that will be done and that will naturally then be the basis for exchange of information. In that cases, we have to say that they have to be strictly proportional and necessary, and that the national authorities have to have a register also with the justification, the motivation for these searches. And so all these kind of registers should be assessed by the national authorities of data protection and, as I said, even by European authorities in this area. And so this could be a strong guarantee. And then going to the remark on Brexit, we haven't yet discussed it. We have referred the issue, but not really discussed it among us, how to reflect this concern that is really a concern now. And so I thank Sophia in 't Veld for having this issue, because we have mentioned this in our first, I'd say, exchange of views, but then as the work is so technical and so broad, we didn't mention this afterwards, and so I will take this contribution in account in the next Shadows meeting in order to also address this issue that is a very important one, and probably now even more important than 1 month ago or two, because we are seeing some developments that are not really encouraging. So thank you very much.
Thank you very much. Thank you for the answers, and thank you for your cooperation. The reporter stays the same, but we can move to the next point. Draft Council decision on the full application of the provisions of the Schengen acquis in the Republic of Croatia. The reporter is Paolo Rangel. So now he will present his draft report on that, and I would like also announce and emphasize that the deadline for amendments for this file will be on 13th of October, 12 o'clock. Mr. Rangel, the floor is yours.
Thank you very much. So I would stress as a first statement that Parliament, by the way, together with the European Commission, have been the driving forces in order to grant that Schengen area is not fragmented and that the enlargement of this area is a major pillar
for the freedom of the citizens and for the reinforcement of integration at European level. And it is clear today that from the point of view of the European Commission assessment and also the the Council assessment, it is quite clear that Croatia really fulfills all the requirements to join euro area. A Commission in 2019 has stated this. The Council in December 2021 also has confirmed formally that the member state Croatia is totally prepared to adopt all the measures that are required for this integration in Schengen area. By the way, Croatia is till now, the only member state that implemented independent mechanism of monitorization and control of the activity of the authorities. It is an independent board that, by the way, also has some European contribution, and probably this is a model that we should reply in all member states that have external borders of the European Union. This being said, let me say that I was in Zagreb in the border with Bosnia-Herzegovina in these 50 kilometers that are very, very near, very close to Slovenia. So that is where is Bihać and Lipa camps and others. It was really very, very important in my view to see that they have incorporated the best technology that we could have, that the police seems to be very well prepared to cope with the fundamental rights issues. They have instructions. We spoke with some of them and this was really quite instructive. Also for me it was a very, very good experience to see the reception center in Zagreb, the main and most important in Croatia, where I could freely speak with a lot of refugees. By the way, very astonishingly, from Cuba and from Burundi, that are now the ones that are most important as migrants that are requiring asylum, because, as you know, Serbia has no visa requirements to these two countries because they don't acknowledge, they don't recognize Kosovo. And then there is a huge, I'd say, number of citizens from Cuba and from Burundi that are now asking for asylum in Croatia. And I have to say that it was very, very impressive the way they portrayed it, the way that they were treated. As I can speak Spanish and French, I could do it freely and in a random way with a lot of them that were there. And it was really quite impressive because they said they were very well treated and very relieved to be there. So after a journey that was not so easy through Bosnia. And so it was really encouraging to see that in both dimensions, security by one hand and fundamental rights by another one, it was a quite satisfactory assessment that I could do with my own eyes. And this is my report on this first phase of our activity.
Thank you very much. And now we should listen to Shadow Reporters' remarks. In the name of SND, Matthias Nemeth is registered, but he's absent. So, Madame Joncheva, the floor is yours.
I think first of all, Elena will read out some notes of Matthias. Thank you.
Elena Joncheva.
Yes, thank you, Chair. I will make a statement on behalf of Mr. Nemeth, the S&D Shadow Rapporteur, who cannot be with us today. So I want to thank the Rapporteur for its report. In the S&D, we have always been strong supporters of Schengen accession. Once the necessary requirements are fulfilled, internal border control should be lifted. And this should apply to all the countries. In that spirit and in order to speed up the process, the S&D supported the request of the rapporteur to work in English only, just as we support Croatia's Schengen accession and will vote in favor of this report. However, with that in mind, we cannot completely ignore reality and all the discussions we have had in the European Parliament in that past, in particular as regard Croatia's management of the external border. I will therefore table few amendments to the recitals in that regard. I look forward to working with the rapporteur on this important dossier, and I sincerely hope that we can welcome not just Croatia, but also Romania and Bulgaria in the Schengen area very, very soon. That was the statement of Mr. Nemetz. Thank you.
Thank you very much. I understand that on behalf of new groups of Infeld will speak.
Yes, today I have the honor to speak on behalf of 3 of my colleagues. What a joy. Okay, so Jan-Christoph Utjen, who had to leave because we were running a bit late, he asked me to say the following. I thank the rapporteur for the draft report. We all agree that Croatia shall become a part of the Schengen area as of the 1st of January 2023. That is why the political groups agreed on doing a quick procedure with English only and short deadlines for amendments. Nevertheless, there are issues that have to be addressed concerning the accession of Croatia to the Schengen area, namely the reports of pushbacks of migrants and the role of the monitoring mechanism that has been put in place in Croatia. First, concerning the pushbacks, let me make crystal clear that those are illegal, and every time a person is prohibited to claim asylum, a country is violating international laws. Croatia, as a future member of the Schengen area, has to comply with international law. This issue shall be addressed in the report. Second, as Renew Europe, we are aiming for having a monitoring mechanism for the respect of fundamental rights at the European borders. But this monitoring mechanism has to be independent and free in its way of controlling the respect of fundamental rights. Our amendments will aim to strengthen these aspects. Thank you.
Thank you very much. And the next speaker is Eric Marquardt from Greens.
Yes, thank you. I will speak in German. Genau, also erstmal vielen Dank auch für die
Well, let me begin by saying thank you for the presentation and the contributions that have already been made, but I want to say, in line with what we said in the Shadows meeting last week, that as the European Parliament we need to be very serious in what we do, and we need to be very serious with regard to the process as well, because 2 member states have made it clear that they want the European Parliament to look at this and look at which challenges we can deal with. So at the end of the day, I don't want us to simply agree that we all say, well, this is a great thing and we need to give Croatia Schengen membership. I mean, we need to look at how we can make this happen and also ensure that NGOs and the Council of Europe's anti-torture committee, the Croatian government, and everyone agrees, because everyone said there's this problem with human rights on the external border, and we also need to be aware that at the end of the day we need to not have chaos going on in the Schengen area. We can't simply have people going across the Schengen border 5 times and then them being pushed back and beaten. I mean, this is a situation that we've seen many times over the years. We've got proof that it's happened. And in addition, the Commission hasn't really shown any serious interest in implementing any kind of monitoring mechanism. So I think if this were to be implemented, it would be a good thing. And I think if we're going to welcome Croatia as a member of the Schengen area, we really do need to have this monitoring in place. I would also say that it's important that the European Parliament doesn't give the impression that there are simply deals being cooked up here You know, so that one political group says, yeah, we'll have Croatia as a member of the Schengen area as soon as possible, and the other groups say, okay, as long as we have this other country as a member as well. So we really need to do our homework properly, and I hope that, okay, in spite of the short deadline, we will be able to have a majority for an amendment which would lead us to talking to experts and deciding as to how best Croatia could become a member of Schengen.
So we can move to ECR. Understand, Madam Kempa, in the name of Mr. Brudzinski? No. Okay, so we can move to the next group, Clara Daly, the left.
Thanks, Chair. I'd certainly echo a huge amount of Eric's points there. I mean, as far as we're concerned, all EU member states who want to be in Schengen should be in Schengen. I actually go further and say I'm not really in favour of any borders at all. But I have to say the timing of this is problematic, because it certainly smacks, if you like, as a reward for Croatia for the most grotesque abuse of refugees at its borders. I mean, the EU, let's face it, has been using Croatia as an attack dog against refugees wanting to get into Fortress Europe, and now they're being thrown a bone in the form of Schengen accession. And the problem here really is that there hasn't been an independent monitoring mechanism. It never existed independently, and it doesn't exist now. And when it did exist on paper, or in name anyway, it couldn't find any evidence of the 9,000 people who were pushed back from Croatia last year, or the more than 16,500 which were pushed back in 2020, all of which were completely illegal, all of which in flagrant breach of the Geneva Convention. And we've discussed this numerous times on the Schengen Scrutiny Group, and I agree with Eric's points. We have a responsibility to take our job seriously, because we know there's been countless number of refugees, including children, beaten, imprisoned, tortured, raped, branded by Croatian border guards. Zero accountability for any of this, zero investigation. Instead, we've had lies being fed by the Croatian authorities, which has been absolutely demonstrated in relation to the CPT report, and the Commission doing nothing. So sorting this out actually isn't hard. Proper oversight and accountability into the abuses, and they would soon stop. And we should be demanding this and putting it into the report. So I'd strongly echo Eric's points in that regard, and also with the idea of getting experts in. Croatia needs to get its house in order on these things, as far as I'm concerned. Thanks.
Thank you very much. Important things. I will now give the floor to Mr. Rangel.
Yes, please. Let me make very clear that first, there was all the assessments that are required. They took place, all the assessments that are required to integrate Schengen area. This was clearly done by the European Commission and by the European Council, by the Council, I have to say. And then, let me say that it is not true that this mechanism, that is something that the other member states, they don't have, that is not independent. No, it's not on paper. Brigitte, I regret to say, I had a meeting with the Ombudsman there, more than 1 hour. She is very critical of different situations with authorities of Croatia, and in this respect, she really welcomed this independent mechanism. And she said that it's working, and it's working well. More than that, she said, there is no systematic violation of human rights. There are cases, 1, 2, 3, that are reported and that she investigated. She even said that on that case of 2017, where Croatia was condemned by the European Court of Human Rights, even now, the police, on their education program, they studied this case as a role model for the behavior that they should adopt. And so this is quite instructive thing. So we should not go only for these things. Then I have to say that this description and narrative that Clara Daly gives, it's of course, it doesn't correspond to the situation that we know. Because if we had this kind of report, naturally everybody would know. that people are raped, beaten, tortured, even probably killed by the Croatian border guard. This has any fact basis. It's not fact based. There is no reports of that. I'd like to know one situation that is really real on that. And so, please, I think that we should be quite neutral, independent, impartial, and look at the reports of the European Commission, the reports of the Council, and naturally also of this mechanism, because I'd like to know if other member states, if they have a mechanism like this. They don't have. They don't have. What I agree is with our colleagues from Renew. We should now be inspired for this improvement of a Croatian government and to have an independent mechanism at European level that would apply to all member states that have external borders in Schengen area. That should be, of course, an improvement for all European zone. And this is a quite important achievement. And here I fully agree with our colleagues from Renew that we can even do it in a better way and applicable to all member states and not only to this one.
Thank you very much.
Yeah,
I've noticed. But
just a point of order, just because evidence is important, and the Committee for the Prevention of Torture published a report which they had to publish because it was denied by the Croatian authorities of abuses. So it's not a fantasy; it's a fact-based allegation that was made here.
I'm sorry because, first of all, Sophie Infeld was first. I don't like to prolong this discussion, and I would like to propose you, because once again, I would like to emphasize that we have a deadline for all the amendments. This is Thursday, 12 o'clock, 13th of October. And if you would like to have, and you have remarks, and you would like to have, I think maybe shadows meeting is also needed for that. But I believe that it will be noticed and emphasized in the final report because of the neutrality of the reporters in this case. If we will open the discussion, we'll be out of our timing. And Sophie Infeld, once again, could you...
Just very briefly, because my group is in favor of the accession of Croatia, but I think it would be helpful for the debate and mutual trust if we also accept the evidence. And the point is that when we were talking about Greece and the pushbacks, for a long time, some in this room said, no, it's not true, it's not true. The Commission said, oh, it's not true. Frontex said it's not true, and then it was true. And the evidence was there for many years. And you cannot say only because it's, I don't know, NGOs or journalists or whistleblowers that it's not official information. Come on, we've been hearing about problems in Croatia for years. So it's much better to accept it, to be honest about it and address the problem rather than denying, because quite frankly, then I get a little bit worried. If those are the conditions under which we are going to vote in favor of accession of Croatia, I mean, if we're not all on the same wavelength, if we're not all deciding on the basis of the same facts, I'm getting worried.
Thank you. The final answer, please. Final answer. 1 minute.
I'll be very brief. I have to say that I didn't say that there were not problems, as they exist in every country that has external borders. Yes. But what I said is that the description that our colleague Claire Daly, that I much respect, and is a colleague that we work together very, very well, but that is not fact-based, because it's the description almost of a situation of war, where people are raped, beaten, tortured in such a number. This is not true. That's what I said. I didn't say that there was not here or there cases where we should pay attention to that. But in that respect, I have to say that it's better to be inside Schengen than outside, because our capacity of controlling is even better if there are some incidents that really don't respect fundamental rights.
Thank you very much. I'm sorry, so once again we are We are moving to the point 7. Amending regulation listing the third countries whose nationals must be in possession of visas when crossing the external borders and those whose nationals are exempt from that requirement. For instance, Kuwait and Qatar. This is the report which is prepared by Eric Marquardt. So, as in the previous case, I would like to ask Mr. Reporter for the presentation of draft report. The floor is yours.
Yeah, thank you very much. And once again, I will speak in German because my notes are in German, unfortunately.
So, well, let me begin by saying that what we're doing with this file is coming up with a group of states, and we're moving them from the list of states that third countries that need visas to the list of third countries that don't. And the basis for this is that since 2018 we've had a visa codex, and there is a list of criteria which leads to countries not having to apply for citizens of third countries not having to apply for visas if they fulfil the criteria. We discussed this in shadow meetings, etc., to see which effect the European Parliament can have on these criteria, how we can have an influence on the criteria which states have to fulfill. And what we've done before the summer break, when I got this file as rapporteur, well, we met Human Rights Watch, and the case of Kuwait and Qatar is that we didn't propose a visa waiver for these states because they're the best countries in the world in terms of human rights and because they stick to all labour rights. We did it because we believe that a visa waiver would provide advantages on both sides and would also mean that perhaps together we could try and improve the situation when it comes to migrant workers in those countries, women's rights, LGBTIQ rights. And Human Rights Watch spoke to a shadows meeting, and the agreement among shadows was that it's a good thing to move in this direction, and that's what my report says. We should propose Kuwait and Qatar for the visa waiver list, but they do face major challenges, particularly with regard to human rights, as I've already mentioned. So we don't really see this as a reward for anything being given to these two states. It's not for what they've already done, but it's a step along a path that we will go together, as I mentioned. I think that we have to have a discussion with regard to putting further states on this list, and perhaps I'll go into that later. I mean, we need to continue to discuss this in shadow meetings, I think. But I think the clear case is, why hasn't Oman been proposed? And that's something that I asked the Commission to respond, because the Commission hasn't yet carried out its assessment on Oman, and Ecuador is another one. The Commission would say that Ecuador doesn't yet fulfill the criteria that have been set out. But during further discussions, we'll have to look to see how we can ensure that Kuwait and Qatar get on the visa waiver list, and then the process stops. We need to ensure that the Commission actively looks to see which third countries should be considered. And I said in my report that Oman and Ecuador should perhaps be next on the list, and then we should have a look at see how we can get more third states on the visa waiver list. But I don't want to go on at too great length, so I think I'll leave it there now. Thank you.
Thank you very much. Time for shadows reporters. 2 minutes each. Xavier Zarzalejos on behalf of EPP.
Gracias, presidente. Hablaré en español.
Thank you very much, and I'll be speaking in Spanish. I'd like to thank our rapporteur. The EPP will broadly agree with the reasons that have been stated for the striking of the two countries from the visa-free requirements list. Now, this is a strategic decision. So this will help to boost, strengthen ties and boost relations, and it'll be important to leverage a strong incentive, if you will, to encourage a more structured dialogue on a level footing to broach very important topics of mutual interest, including human rights, of course. The rapporteur mentioned the discussions that have been held amongst shadow rapporteurs. And with regard to Ecuador, I can say we will propose that Ecuador should be included in the regulation and be taken off the list of countries requiring a visa. Now, there's a further point I'd like to explain with regard to the thrust of our proposal. Now, for Kuwait and Qatar, we know that the procedure is further advanced when it comes to the procedure for accessing this visa waiver. Well, we know that Ecuador is not at that same stage when it comes to getting that report from the Commission and a bilateral agreement. However, Ecuador is an important economic partner alongside Colombia and Peru. Colombia and Peru already benefit from this kind of visa-free travel regime. Ecuador has a biometric passport. It has specific legislation in place to enable returns to the country for those individuals who have to be sent back. And also, Ecuador really does tick all the boxes when it comes to our general wish to strengthen ties with Latin America, and it is strategically placed in this context. So the EPP will be supporting this initiative. Thank you.
On behalf of S&D Group, Pietro Bartolo, the floor is yours for 2 minutes.
Thank you very much, Chair. I would like to thank the rapporteur for having prepared this document in such a relaxed and cooperative manner. Now, we've already heard that Kuwait and Qatar have been fundamental partners over the years, and particularly in terms of the management of the recent crisis, the health crisis, and the war, indeed, in Ukraine. These two countries are strategic economic partners for the EU. Given recent geopolitical trends, they're undergoing considerable social reform and indeed legislation in that regard has been passed recently regarding a minimum wage and other labour requirements. The ILO and the ETUC have both adopted positions vis-à-vis these two countries and have acknowledged the progress made. Now, they're definitely in a better position than other Gulf states, including those who already have a visa-free system, such as the United Arab Emirates. However, there's a lot of progress which remains to be made, and the rapporteur has said this. And I agree that we must continue the dialogue on human rights, and the development of that dialogue was clearly explained to us by the EAS in a meeting which we had recently. And here I agree with the proposal to introduce a clause which would lead to periodic revision and would take stock of the state of play in terms of human rights. And I think that that clause could be applied to countries who already avail of visa exemption. Now, this should lead to mutual advantages to the parties concerned and full respect for the criteria laid down in Article 1 in the appropriate provision. So I take note of the fact that the rapporteur has included in the recitals the idea of including Ecuador among countries which would be visa-free. We're not against this inclusion on condition that this does not delay the approval procedure of the proposal. And it is of the exclusive competence of this committee. We must ensure that all parties are heard in line with the principles of the regulation which I just mentioned. I would like to thank the rapporteur, and of course I will reserve the right to table amendments.
On behalf of Renew Group, the floor is yours.
Thank you, Chair. Thank you, dear Eric. Dear colleagues, it goes without saying that the situation in both countries is, it raises serious concerns. It's not only on the perspective of rights, but also on security. We all know that, both these countries, they still have the death penalty. Both these countries have a long way to go when it comes to women's equality with men. And don't let me get started on the LGBTI rights perspective in these both countries. At the same time, I'm of the view that it is only through dialogue that we can also enhance our values in other regions of the world. I think that we should use this legislative proposal as an opportunity to push further for our human rights agenda in these two countries. And of course, we will propose some amendments that will go in line with both enhancing the dialogue when it comes to human rights perspective, but also on the security, because we need to cooperate even more on that issue, and these two countries need also to do more when it comes to this matter. I do believe that dialogue is better than isolation, and I do believe that these two countries might be prepared, given that they will deliver on their commitments to both human rights dialogue and the security dialogue. Thank you so much, Eric, for a very good and inclusive process until now, and I look forward to make this legislation done as well. Thank you.
Thank you very much. We can move to the next shadow, but I've seen this the same situation as before. No one from ID and not from ECR, as I understand. So the left, Claire Daly.
Thanks, Chair. Look, we're in favour of visa waivers basically for any third country that wants it, but the truth is it is kind of a privilege, and it is something that's afforded to only a minority of countries globally, with more than 130 who don't have this concession, if you like. And of course we are legally obliged to consider the human rights impact as part of it, and I'd like to thank Eric for his report. It is strong on the needs for the human rights dimension in the proposal, but I think it could be even stronger, and I think we should be demanding that the Commission impose very clear human rights conditions on both Kuwait and Qatar if they want to get and if they want to keep a visa-free regime with the EU. And as far as I'm concerned, there should be a clear mechanism in which to trigger a suspension for human rights reasons. And it's very obvious in talking to the Commission and others in our previous meetings that this is not there at the moment. But to be honest with you, even with that, I think this is a terrible proposal at the moment. I mean, the timing is just desperate. It is going to catastrophically undermine whatever is left of the perception of the EU as an actor that cares about rights and values. And in that sense, it is definitely going to undermine whatever soft power is left and undermine what's left of its global standing and reputation. I mean, the speakers who came in were very clear that the reason this is being pushed ahead of the likes of Ecuador, who are far more deserving as far as I'm concerned and should be considered earlier, is that a new source of energy is required. There are geopolitical considerations. So if you like, we're not going to do business or trade energy with Russia because they're authoritarian and they're involved in a war in Ukraine, but we will do business with Qatar and use theirs because they definitely are authoritarian, no political parties, no judicial independence and all the rest, and they're in a war with Yemen. looks bad on the world stage, to be honest, and it's going to look particularly bad when it's been launched in the middle of the World Cup, when the focus on all of the migrant deaths, literally worked to death. I mean, we should be demanding, the Commission didn't answer it, what redress has been given for those workers who lost their lives in the building. I think it looks terrible at the moment, but we can beef up the human rights aspect in the report. Thanks.
Thank you very much. We've just finished the time for shadow reporters, but I've noticed also one additional request, so Mr. Moreno Sanchez, additional remark from S&D.
Sí, gracias, presidente.
Thank you very much, Chairman. I thank Eric for his work. And let me stress something that Mr. Zarzalejo and Mr. Bartolo have said. Back in July, we met Vice President Skinas, and we said that it was important to include Ecuador in the list. Now, as I've said, this is not going to slow anything down when it comes to the other two countries, but we need to really make sure that we are actually putting our focus on Latin America. We know that this is going to be one of the priorities for the Spanish presidency, so if we want to move forward, then obviously, respecting the entire procedure that's been set out, we would support the amendment that would call for this addition. Thank you.
Thank you very much. My final announcement, because I didn't say earlier, the deadline for amendments in this file is Friday, 14th of October, and the summary by Mr. Reporter.
Yeah, I actually will not summarize everything. That would be stupid. But from my point of view, just to say one sentence, I in most of the cases deal with other kind of migration files where we have very different opinions in different parts of the room. So it's actually also good experience also for my heart to see that we can have a file where most of the people want to walk in the same direction. That is nice, and I am just looking forward to see the amendments. I think there are good reasons for tabling different amendments, as also mentioned by you, and I hope that we can also find a common agreement on how to, as fast as possible, get also other countries, as we discussed, on the list. And looking forward to work further with you on the file. Thanks.
Thank you very much. We can move to the next agenda item. It's point 8, laying down detailed arrangements for the exercise of the right to vote and to stand as a candidate in the municipal elections by union citizens residing in a member state of which they are not nationals. The reporter is Joachim Stanisław Brudziński. I understand that Mrs. Kempa will present Mr. Brudziński's draft report, and in a similar situation before, we will have remarks and questions from the shadows too. The floor is yours, Mrs. Kempa.
Bardzo dziękuję, pani.
Thank you very much, Chairman. I'll speak Polish. Replacing Mr. Brudziński, who is unable to be with us today, but I'd like to give you the following information. The purpose of the Commission's proposal is to change the conditions of applicable to the exercise of the right to vote and to stand as a candidate in municipal elections by union citizens residing in a member state of which they are not nationals. This is part of a package on transparency and democracy. Every citizen can participate in the democratic life of the European Union, and decisions should be transparent and close to the citizens. Citizens that reside, study, work, or do other activities in member states whose nationality they don't possess may vote and stand as candidate in municipal elections as described. This proposal is a recast, so it is an update of the directive in some areas. In particular, member states will appoint bodies that will inform moving citizens on the conditions of registration as voters or electors or candidates. Now, as regards this informing obligation, so that the citizens have better understanding of the regulations, the relevant bodies will provide such information, detailed information, on first, the status of the registration, the dates of the elections and the applicable conditions, as well as applicable obligations, as well as any bans that may be applied or sanctions that may apply if the rules are not respected. Apart from that, a single form is proposed for the purposes of registering as voter or candidate. For example, citizens may also have to present proof of citizenship. The fact that submitting such a statement may dissuade people from voting or standing this obligation may be given up. Now, member states may require a certificate based on some other factors. Now, as regards the proactive obligation to inform the citizens is justified, because these arrangements allow citizens to participate in local elections, and they can thus exercise their right to participate in democratic life of the European Union. There are some shortcomings. For example, the registration of citizens could be facilitated and simplified, and they could also have better access to electronic voting, such as the rights or the possibilities given to citizens of the given member state. The proposal has the purpose of providing clear information at the right time. It is also important that the reporting of the implementation of the directive is based on common indicators, so that the Commission should prepare such indicators applicable to all member states. The rapporteur thinks that the new arrangement should not involve any costs on the part of the member states, or they should be limited. We count on constructive involvement of all the political groups in our work on the draft.
for comments of the shadow reporters. The first one is Paulo Rangel on behalf of EPP Group. The floor is yours.
Thank you very much, Chair. I also would like to welcome the report of Mr. Brzezinski and also this information that we received here now. I think it is a quite balanced report. This is a very, very crucial matter to grant that all the citizens that are European citizens but non-nationals have the right to vote in local or municipal elections. This is really a very important right, and we have to guarantee, to assure that these citizens are in the same conditions, are not discriminated, that they are able either to vote or to be elected as candidates in these local elections. In this respect, it is very important that they have the capacity to understand all the rules, and that means that they should have information in their own language, and this should be done in a clear and transparent manner in order to grant that they are entitled to vote and even to be elected in this case. And naturally, it is also important to grant that the people with disabilities are also in an equal situation of the other citizens. And this is quite important in every election, but also in local elections, because local government normally is responsible for the policies to grant equality of people with disabilities. Finally, naturally, it is important that the register where people can put their names and even cancel if they are going out of this country or out of this city, that they are quite simple, because this is probably one of the main difficulties that we have now, that is the bureaucracy that is associated with this right to vote. And so I'd say that I think that the report is a quite constructive one, and that we will have a very good result at the end, granting the rights of all European citizens when they don't live in their national state.
Thank you very much, and I would like to ask Domenic Ruiz de Veza from S&D Group. The floor is yours.
Muchas gracias, señor presidente, y gracias, por supuesto, a la colega que habla.
Thank you very much, Chairman, and I'd like to thank the colleague who spoke on behalf of the rapporteur, Mr. Kuczynski, and so I'd like Brzezinski, excuse me. So I'd like to thank him for his draft report, and I'd also like to thank the other shadows and their teams as well. Now, there are many concerns that we share. For example, the need for EU citizens to receive information which is clear and understandable, which is received in good time as well, so that they can participate in local elections. But I would like to point out, as a general comment, that the recast proposal which comes from the Commission is something that we're perhaps seeing too often. This recast procedure is useful when it's justified, but we shouldn't let that procedure deprive the Parliament of its rights as co-legislator. Now, on the content of the directive, as has been said, the Commission's proposal is positive in general terms, as is the proposal made by our colleague Mr. Brzezinski. But there are two elements, I think, which we see as perhaps not fully democratic. There are perhaps justifications that could have been brought to bear while the European Union was being built 20 or 30 years ago. I mean, perhaps these exceptions are there for a reason, but I don't think that they're in line with the spirit or the letter of the treaties, and they're not in line with the spirit of the times either. And here I'm referring to the possibility maintained in the proposal that member states can restrict the posts that people can stand for so that not foreign nationals can't stand for all posts. And that would mean that in some countries, an EU citizen would have the right to vote, but not the right to stand for some posts. They might be limited in what they can stand for. I mean, they may well be able to be, for example, part of a local council, but they may well not be able to be a mayor, for example. So there could be limits on what they can stand for. We also don't understand why Article 13 would retain the exception which restricts the right to stand and also the right to vote if the proportion of EU citizens is over 20% of the area in question. As I say, I think these restrictions are unjustified. I mean, I think in general terms, we could call these exceptions or derogations. We could say that they responded to the request of perhaps certain member states in very specific situations. But I think given that now the Commission is proposing a new directive, we should take this opportunity to get rid of those two exceptions, which we see as undemocratic. To conclude, Chairman, we believe that we should think about moving towards fully universal suffrage. I mean, citizens of other member states should have the right to vote not only in local elections but also in regional and national elections because they live, work and pay taxes in the country in which they are resident. And as we know, there should be no taxation without representation. But it's true that current treaties limit these rights to local elections. Well, given that, let's at least guarantee that right fully. Thank you.
Jana Tom is not with us, so Sophie Infeld in the name of Renew Group.
I'm wearing 4 hats today. So some people might say I have a multiple personality disorder. Okay, so on behalf of Jana Tom, I would like to thank the rapporteur for his work on this draft report. It is high time that we have a look at the access to electoral rights for Europeans that choose to live in another member state. We cannot talk about true freedom of movement unless we are able to keep our electoral rights even after crossing borders. 28 years after the adoption of the original directive, voter turnout amongst mobile Europeans is still low compared to nationals of host member states. As the proposal we have in front of us is a recast procedure, I believe we need to keep our work technical and targeted. But in order to ensure equal access to elections for mobile Europeans, we cannot allow another 28 years to go before the next proposal to make changes. In terms of our work for now, I believe we have to look at automatic voter registration. Half of all member states do not allow for automatic registration to non-nationals. In actual terms, this just means another hoop that mobile Europeans have to jump through. I also agree that language can be a barrier for voting, but I don't believe that every information has to be translated into all official union languages. It should be enough to have the relevant information available in the big languages. Last but not least, if we want to understand the problems that mobile Europeans face in voting, we need to have better statistical data on their participation in elections. Here, I believe it is relevant to come up with common indicators at a European level. I look forward to working together with you colleagues in order to help mobile Europeans have a say in the decisions that affect their day-to-day life. Thank you.
Thank you very much. I don't see Damian Beselager. Somebody from Greens? No. I cannot see anybody from ID Group too. So Kostas Arvanitis, the left.
Thank you very much. In general lines, we agree. All the way from the EPP to the left on the necessity to allow those people to both vote and to stand as a candidate. So I want to point out 4 things in this discussion in order to come up with a synthetic process that will lead us to something more constructive, and so as not to wait for another 28 years, as Sophie said. I think that we need to develop a comprehensive system to allow people to register more easily. So the EU should provide an incentive to people to participate. This is the main wager here for democracy. If citizens coming from another member state but residing here in Belgium must be able to vote and stand as a candidate, and this would allow them to have warmer feelings towards Belgium and the EU. Whether there needs to be communication in several languages, as mentioned by our colleagues. Here, I disagree with Sophie. I think this is a point where we need to actually look at all the different languages, because they are part of our wealth, part of our legacy. So if there are people in a municipality or in a region where we don't have any citizens of another country, perhaps we shouldn't translate the documents in that language, but we should provide this wherever possible and needed, because I know that Sophie didn't mention it for that reason, but I'm afraid of this imperialism of big languages in the EU, because there is a special value added for Bulgarian or Flemish or other languages to be heard. And then we need to also look into the data behind the participation of these people and these citizens. We need more transparency in all member states. And one last thing, in order to safeguard a multifaceted democracy, we need to coordinate some actions and achieve some synergies from different bodies, political parties, civil society organizations, etc. Thank you.
Thank you very much. 2 announcements in this moment from my side is the deadline for amendments is 18th of October, 6 p.m. And the second information is very important. The vote is earlier, so the file will be needed to be moved from 8th of December to 1st of December. The voting will be on the 1st of December, the week earlier. And in the end, Mrs. Kempa, I would like to ask you if you'd like to summarize the comments and the remarks. The floor is yours.
Bardzo dziękuję, Panie Przewodniczący.
Thank you very much, Chairman. Thank you to all the shadow rapporteurs for their precious remarks. We are waiting for your amendments, and I'm sure that the rapporteur will take all of them into consideration and integrate as many as possible in his report. When it comes to shadows meetings, Mr. Brudziński will present a timetable at a later stage. Thank you very much.
We can move to another one. Point 9, but I cannot see the reporter. Do you have any information? So maybe we can change and move to the next one, because
Actually, I'm
see
here.
Oh, yes? Okay, I'm sorry. So Lena Dupont is connected with us. So once again, I will move to the point 9. Information exchange between the law enforcement authorities of member states repealing Council framework decision. The reporter is Lena Dupont. So I would like to ask the reporter for presenting us the draft report.
Yes, thanks, Chair, for the words, and thanks to the shadows for the good and fruitful and at any time solution-oriented cooperation on this file. Given that we managed to conclude the work in this file in, let's say, a record time, Also, of course, thanks to our staff and to our advisors who have been really doing an excellent job on that. The overall report, the overall proposal is part of the Police Cooperation Code, and it's a directive aiming at strengthening the internal security of the European Union and protect our invaluable Schengen area. It's provided clear rules and simplified procedures that will facilitate the much needed exchange of police information across borders, because we all know that the alarming figures are on the rise, and ruthlessness of organized crimes and organized crime gangs make legal action quite urgent. Today, serious and organized crime no longer stops at borders. Police and law enforcement cooperation often enough does so still. To fight these criminal networks effectively, police officers need to cross the EU. The borders must be able to cooperate systematically and according to clear and simple rules, not only in real life, but also when it comes to the information exchange. The existing framework, which was the Swedish framework decision, was too complicated and cumbersome for some of its users, so they consequently did not make use of the full potential of such cooperation, or were inhibited by the legal uncertainties it implied so far. An update of this framework is overdue and has been done by the Commission with the proposal that we had as a basis for our report and our work on that. Every police and law enforcement authority we have heard and visited in the course of preparing the report explicitly welcomed harmonizing the rules as proposed by the Commission, such as the use of Siena as a standard communication channel, and the forwarding of relevant information to Europol was also met with widespread approval. Of course, we're not adopting a directive in the exclusive interest of police forces. It's a question of carefully balancing our security interest with data protection and the right to privacy of our citizens. The changes we introduced do not address the practical problems from effective exchange of information, but prudently weigh up these legal interests and provide or contribute to the necessary clarity and legal certainty, which is of utmost importance here. We took into account the recommendation of the European Data Protection Survivor, and of course all data protection rules must be applied in their entirety in all exchanges. The second part was differentiating the scope from serious crime to all crimes, which is streamlining the provision with a PRIM framework, and Member States' authority will have to respect well-defined time limits to provide the requested information. Depending on the urgency and type of the crime, for serious crimes, of course, with shorter time limits than for those who are non-urgent requests. So we introduce a kind of cascade in relevance to the urgency of the request. More clarity and a less diverging practice in Member States will be added through a harmonized design of the principle of availability. One of the key principles in this proposal should not only refer to information that is already held by an authority, but also to information that the authority can obtain from other public authorities or from private parties. Due diligence will of course have to be applied when assessing requests, especially submitted by a Member State that is subject to an Article 7 procedure. And last but not least, we found a balanced compromise which makes data storage in the case management system viable in practice while consistent with fundamental rights obligation, also following the advice from the EDPS here. We have come to see how important mutual trust between authorities is and how much this trust influences, of course, also the cooperation. More harmonized rules will allow increasing this trust and mutual understanding, indispensable for any operational cooperation and to overcome the shortcomings police officers often are confronted with in their daily work. Criminals are far too often well aware of these gaps, and we need to really take up and step up so that we can close these gaps and use it for our advantage, not for theirs. Only with clear, simple and harmonized rules we can respond to the security threats in the Schengen area and maintain our internal borders without control. And in the light of that, I again want to thank you, the colleagues, for the good work on that, and of course also the staff and the advisors for doing an excellent job. And I'll ask for your support in the later votes you will be doing after when they're in the voting session. Thanks, Chair.
Thank you very much. Thank you, Madam Reporter. Please note that we will vote on the draft report and the decision to enter into institutional negotiation today. Today at 6 o'clock we will start the votes, but now is this time for shadow reporters. And I see only Claire Daly within the group, but I understand that also Sophie Infeld will... Yes? Oh, I'm sorry. Okay, so let's start in an order. What about the Renew Group? No. So then from Greens. Yeah? Sophie, in the name of? No. So Greens, the first.
Okay.
The floor is yours.
Voy a hablar en mi segunda lengua, en español, si queréis utilizar la traducción. Brevemente, quería...
Very briefly, can I congratulate the rapporteur and the shadows for their excellent work. I do think this report will bring about improvements for police cooperation and in areas of serious crimes, organized crime, drug trafficking, fraud, trafficking of other types, and also IT crime and terrorism. Now, I should point out, although this has been checked at the technical and political level, the Greens were unable to do away with the reference in Compromise 3, which constitutes a red line for our group. It talks about the making available of contact points to other member states. So member state information that may be obtained from private entities without coercive measures. Now, for us, this really goes too far, and we do not believe that the sufficient appropriate safeguards are in place to guarantee fundamental rights are respected. So in Compromise 3, if Compromise 3, and we have requested a separate vote, if that goes through and is adopted, so we call on all the groups to vote against that, of course. But in the event of Compromise 3 going through and being adopted, we will vote against the report as a whole, because we do not feel that we can put fundamental rights on the line in this way.
Thanks, Chair. And it is a slightly odd situation that we're here having a debate about the amendments when the file is finished and we're voting on it in a few minutes. But anyway, look, as colleagues have said, this is mostly a technical file. But there are one or two things smuggled in that aren't technical, and we can't support that. And very much along the lines of what Diana has organised, I mean, the provision around private parties and information from them being available without what the report calls coercive measures available to the police, that is, well, we don't think that should be in there at all. It'll just encourage more and more information exchange between private companies and the police with no kind of oversight or safeguards. And we've already heard hints that Amazon might be voluntarily sharing footage from its creepy Ring doorbells with the police in Europe, as everybody knows it's been doing in the US for a while. So we don't think we should be encouraging a cosy relationship between companies whose whole stock in trade is surveillance with authorities that have the power to deprive people of their liberty. That is definitely a step too far, and that being done without any judicial oversight. So we can't vote in favour of this proposal as long as that remains, but we'll see what happens. The other slightly unhappy thing we are about is the provisions on Europol, though we do acknowledge that they have been watered down dramatically in the final text, which is very good to see, but we think that the Parliament has a really constructive role to play here in the trilogue negotiations in making sure that they stay watered down. So apart from that, thanks so much to all the staff who did all the hard and heavy lifting in the technical details on this file so constructively and efficiently. Thanks.
Thank you very much. I'm not fully responsible for this lack of time, but I think it's final decision to be made, so it's not so complicated, in fact of all. I would like to ask Madame Reporter for the answers to the comments. Lena Dupont.
Yes, thanks.
Yeah, the floor is yours.
Thanks, Chair. Thanks again for the word, and just a short comment on the points raised, because we also discussed them in the shadow meeting. I'd like to remind colleagues that whenever a national authority is obtaining data at national level, it of course has to provide and has to fulfill their national data protection needs. So it's not like they can go run around and collect every data. They want to, just as a short reaction to what has been said. And of course, as we had it also in the discussion within the shadow group, I nevertheless thank you for your cooperation, and we were aware of your points. We try to work around them as much as we can, and I now ask colleagues, of course, to support the solution we found in the end with a good majority, so that we can start the trilogue negotiations, taking into account, of course, all the points that have been raised again here in the committee meeting. Thanks.
Thank you very much. We can move to point 10, establishing a European single access point providing centralized access to publicly available information of relevance to financial services, capital markets and sustainability. Our rapporteur is Emil Radev. Mr. Rapporteur is with us, so let's start with the presentation of the draft report. Emil Radev, the floor is yours.
Thank you very much, Chair, honourable members. The Commission's proposal, although quite technical, is extremely important for business, even more for small and medium enterprises, as well as companies from small capital markets. Perhaps the most interesting part of the proposal is that it enables entities to voluntarily submit information which is of interest on financial services, capital markets and sustainability. This, in turn, would make them more visible to potential investors. This is very important in times of a global crisis and uncertainty. Before I present my draft opinion, let me thank the representatives of the Commission. We cooperated in an excellent manner when preparing the opinion, and they were kind enough to answer all our technical and substantive questions. I would also like to thank my colleagues from the EPP Secretariat and the Libe Committee, with whom, once again, we worked very well. So, briefly, what amendments have I made? First of all, I believe that there needs to be a greater clarity as to the bodies gathering information, and in particular those charged with the function of gathering voluntary information. At present, the Commission text lacks sufficient clarity as to how those will be designated. So I would propose that, where appropriate and at the discretion of Member States, the bodies designated for the purposes of this regulation be responsible for collecting the voluntary information as well. This will bring clarity as to which the competent authorities are, and it would avoid uncertainty and overlap in functions. I think it would also save considerable resources, both human and financial. Secondly, I believe that there needs to be more legal certainty in the proposal as regards the voluntary information. Of course, we in no way want to make it more difficult or more burdensome for entities who have volunteered to submit information to the single point. That, however, doesn't mean there should be no certainty as to the truthfulness and reliability of the information. I believe it's critical that entities submitting information voluntarily to do this in good faith. They should also reflect the true state of the data of their companies. They should not mislead potential investors by submitting false or misleading information. Well, think about it. What would happen if an entity, in its desire to attract investment or to show a good financial position, decided to change the information even slightly, increasing a few % here and there in the documents? And this is information that is submitted voluntarily. In practice, there would be no body, no entity that would verify the information submitted in this way. So we have to rely solely on the good faith of subject. It is also very important that the information submitted on a voluntary principle be easily distinguished from the information submitted on a mandatory basis. Personal data protection is also important to us, so we need to ensure that metadata that is collected in connection with the disclosure of this information related to capital markets, financial services, sustainability is not retained for a longer period than the information itself to which they relate. It's also important to have procedures in place. They should be aimed at facilitating cooperation between the data collection authority and the data submitters, in particular with respect to regulating the submitting and withdrawing of voluntary information. I believe that these procedures should be developed by the joint committee of the European supervisory authorities, and they have to take into account small and medium enterprises. Last but not least, it is important that the system we're trying to set up be accessible at all times, except in cases where technical maintenance is needed. Another important aspect is to have statistics on the visitors who use the platform. Not only the number of visitors that give us information about the traffic, but also the number of unique visitors, which gives information on the set of users, that is, the popularity of the platform. So that was the draft report in brief. I tried not to go into detail as to the amendments that I'm proposing, but I also wanted to be precise and clear. Well, I do hope we will work fruitfully together, and I do believe that we'll be able to keep the amendments to a minimum so that we complete the adoption of the opinion in time for the vote in the lead committee, which is Econ. Thank you very much.
Thank you very much. I would like to announce that the deadline for the amendments in this file is on Monday, 17th of October, 8 p.m. So this is 1800, 8 p.m.
6 p.m.
Ah, 6 p.m. I'm sorry. so many hours we are working. Once again, 6 p.m., 18th of October, so in 1 week time. Unfortunately, I cannot see anyone from the group of shadows. Mr. Tank. Oh, Mr. Tank is again with us, so the floor is yours. The question has been vanished. Well, maybe I will ask somebody. Is somebody else who would like to take a floor or to ask? Yes? Are you ready? Okay, so once again, Paul Tank.
Broadly, what I have to say is the specifics I want to remember. Because I know that I know this topic very well. I think one of the crucial aspects to make the agenda of sustainable finance work is to have transparency. It's crucial to make the markets function. If you ask from companies and from financial institutions to not only take care of profits but also at people and planet, they need to have data and good access to data. So data is a public good, and yet we do not treat it that way. So the ESAP can be a public utility, or should be a public utility that makes access to data universal. And is the central in the financial infrastructure central to the agenda of sustainable finance. So SNE is more than happy that the Commission has included sustainability information in the ESAP from the very beginning. The implementing is good, but we need this now. So some areas then for attention, so we fully support that we have a broad data sets, accessible for everyone and preferably free of charge. It's a public good. Some areas of attention, those to ensure that the ESAP will be used, information should be machine readable. The ESAs can establish standards for that. Need to pay specific attention to personal data. Don't let leave sensitive information on a public database for longer than absolutely necessary. And personally, I question also why we need the personal data in the first place in a public database. Ensure that SMEs are not left behind in the corporate sustainability reporting directive. They are excluded from the scope, but at least give them an opportunity to file information to the ESAP. Otherwise, getting funding will be a lot more tougher. Thank you very much, Chair.
Thank you very much, and I would like to ask Mr. Reporter, would you like to answer to the question? No. So, if we can summarize this first part of the session, once again, I have to repeat, Monday, 17th of October, 6 p.m. is a deadline for amendments, and we will close today's committee meeting with a voting session, but it is planned on 6 p.m., so in how many? In 10 minutes. So thank you very much for very good cooperation. I was afraid of so long agenda today, but it was done, so we are on time. In 10 minutes, I would like to ask you to come back with the cards because we'll have electronic voting. So to see you soon, and let's have a short break. Thank you very much.
So, can we start?
Dear colleagues, we would like to continue our committee meeting. We will close today's committee meeting with a voting session. We have several reports and one opinion, as well as votes to enter into interinstitutional negotiations. I kindly remind you that for the decisions to enter into negotiations to be adopted, we need the support of an absolute majority, which is 35 votes in favor. I would like to announce that Moritz Kerner will be replaced today by Gilles Boyer. This is a Renew Group decision, and also I would like to inform you that Mr. Pietro Bartolo, we know very well, has no card, so we will see the votes and we will add to the electronic result, which will be presented by me together with the vote of Pietro. Moreover, I would like to remind you that the last vote of today is a joint voting with our colleagues from Econ Committee, so we will vote together, and then we'll have, so before the voting we'll have to have the break and to count again the quorum. The quorum I would like to check now for Libe Committee. I've seen a lot of us, so there is no question of lack of a quorum, so we can start the procedure. The first voting. I'm sorry if I will be not so smoothly in this process. This is the first time because I have honor to replace our chairman. So the point 10A, the subject, ID's group requests in writing pursuant to Rule 214 to put to vote in the committee the coordinator's decision on point 6.5.2 of the final feedback note of the coordinators meeting of September 6th this year. This is single vote, so we are voting together. We are voting by card. Oh, okay. It's not.
You need to say vote is open and
The vote is open. Okay. Yeah, it's work. Yeah, miracle. The vote is closed. Is it closed?
Yes.
Second.
And then it's carried. The coordinator's decision is carried.
The coordinator's decision is carried. Is 30 plus 1, so it's
34.
34 and minus 23. We can move to the next item. Proposal for a.
She wants a point of order.
The point of order. Yes.
Yes. Bonjour. Je n'ai pas pu. Vous n'avez pas attrapé mon regard tout à l'heure.
You didn't catch my earlier on, Chairman. I wanted to take the floor to express our position on the vote. It's just been mentioned, so I'd like to say a couple of words on that. We just voted on it, but point of order.
D'accord, je vous remercie. Alors, selon un bilan dressé par...
Thank you. Well, according to what the Commission said itself on left-wing and anarchist extremism in the European Union, the speaker is interrupted by the chair.
But we are after the voting.
I did put up my hand very clearly on 2 occasions, so I'm a bit surprised you didn't see me.
On a point of order, she cannot make an explanation of the vote.
Once again, we had a voting because we have a voting session now. This is not a time for discussion and exchange of views. So you can have a point of order if it is connected with an order. So the point is done.
Okay. Est-ce que je peux juste...
Okay, could I just request that we look at all the groups so the groups have an opportunity to speak when there is a motion that's been tabled from our side.
We are not in the point of explanations and remarks. Sorry that I didn't notice earlier, but this is not a case. We are moving to the next point. Proposal for a regulation of the European Parliament and of the Council establishing a collaboration platform to support the financing of joint investigation teams and amending regulation. This is compromise amendments block of votes, so one voting. The vote is open. Now it's better. No, I'm joking. It's plus or what is? No, it's plus.
Vote is closed.
The vote is closed. Yeah, I've seen.
And carried.
Carried 56. Nobody minus. One abstention. The next point, the final vote, okay? The final vote is needed. So once again, the vote is open.
Final vote.
Final vote is final vote. The vote is open. Closed. The vote is closed. 57 carried, nobody abstained, nobody against. Thank you very much. And the vote on mandate interinstitutional negotiations, the last vote in this item. The vote is open. Somebody is not very decided.
One plus too many PPE
Okay.
and too many renew.
I close the vote.
No, too many PPE. It's one PPE too much, one renew too much.
Oh, there are too many votes we have now.
One
from
renew too
EPP
much.
and one from Renew. Too many.
Renew.
One Renew.
That's
Oh,
it.
thank you. Thank you very much. It's carried 53-4. Nobody against, nobody abstained. The next item, Directive of the European Parliament and of the Council of Information Exchange between law enforcement authorities of Member States, repealing Council framework. Also, compromise amendments, we are voting block. The vote is open. If you can close, yeah, the vote is closed. One person against, 56-4. So it's carried and we can move into a final vote. The vote is open. Once again, I have to announce because it doesn't work. The vote is open. Thank you very much. I'm sorry.
No, it was a block vote on compromises.
But it was a block. Yes, it's a separate vote, yeah?
Yeah.
Okay. I'm sorry, my mistake. We missed compromise.
No, separate vote.
Separate vote. Compromise 3. The vote is open. This is the page 11. The vote is open. The vote is closed. We have result, which is 42 for, 11 against, so it's carried. Sorry. Also. Now we can move to final vote. I'm sorry for this missing. The final vote is open. And the vote is closed. And very similar result, 42 for and 12 against. And 1 abstain. We can move vote on mandate interinstitutional negotiations, required majority, 35. The vote is open.
Decision to enter into negotiation.
And the vote is closed. 52 to abstain, so it's okay, it's carried, and we can move to the next point. The next point is resilience of critical entities. One single vote. The vote is open.
You need to speak more in the critical entities. Is a provisional agreement.
Resilience of critical entities. I have to sit closer to microphone. Sorry. Okay. The single vote on that. The vote is open. And the vote is closed. The result is also positive, 53 plus, 1 minus, 2 abstain.
Now he has his card.
Oh, you have your card. So 52 plus 1 minus and 2 abstains. The document is carried. We can go to the next one. Report on racial justice, non-discrimination and anti-racism in the EU. Okay. So we can start with a block of vote. The vote is open. This is the first one.
Then you have amendment 13.
Yeah.
Compromise. 13.
The vote is closed. It's carried. 46 for, 5 against, and 3 abstain. We can move to amendment 13, compromise amendment 13. The vote is open. The vote is closed. The result is 47 for, 4 against, and 4 abstains. Also carried. And we can move
Amendment 234. 234.
to amendment
234.
What is it?
234.
No, I have not.
34, it's on page.
234. The amendment,
Page 10.
yeah?
Here.
Okay.
No, 230. No, 34. From Mrs. Bjork. 34. Mrs. Bjork.
234. The amendment given by Mr. Bjork. Not Madame Bjork. The vote is open. Okay, the vote is closed. It's rejected. 24 for, 31 against, nobody abstains. So we can go to final vote in this draft. The final vote, the vote is open. We can close. So it's adopted. 48 for, 6 against, and 3 votes abstains. Thank you very much. The draft is adopted. We can move to the next one. This is proposal for regulation amending regulation EU number 910 from the year 2014 as regards establishing a framework for a European digital identity. We have to start with Compromise Amendment 13. This is on the page. Where is it? 4.
Articles.
Article 1, yes.
And this roll call vote. All of the compromises are roll call vote.
And this is roll call vote. Amendment 13. The vote is open. Compromise amendment. Yeah.
Compromise 13.
Compromise 13. Yes.
Yes.
The vote is open.
Close.
We can close. It's adopted. 49 for and 2 against. So we can move to the
14.
start.
No,
for the start.
We do all the articles. You need to do
Where
all
is the
articles. 13, 14. We need to go one by one till the end.
So we have to go one by one. The compromise 14. Now the vote is open.
We vote the articles first. So 13, 14, and then we come to recite. Close.
Yes, we can close. 51 for, 1 against. So we can move to the next one. 15. Compromise 15. The vote is open. The vote is closed. 55 for, 1 against. We can move to the next one. Compromise 16. The vote is open. The vote is closed. Oh, okay, the vote is closed. 55 again, 4 and 1 against. The next one is 17.
Yeah. 17.
The next compromise number 17. The vote is open. Amendment 1. We should first. No?
Okay.
I'm sorry. We should vote first. Amendment 119. 119. Yes. The vote is open. The vote is closed. 43 for, 11 against, so it's adopted. So we can move to compromise 17. Compromise 17, the vote is open. The vote is closed. 54 is for, 1 against, so it's adopted. Now we move to compromise 18. Compromise 18, vote is open. Okay, the vote is closed. 51 for, 1 against, 2 abstain, so adopted. Then compromise 19. The vote is open. Okay, the vote is closed. 55 for, 1 against, adopted. Then compromise 20. The vote is opened. Thank you. The vote is closed. 55 again and 1 against. Adopted. 21. Compromise 21st. The vote is open. Thank you. The vote is closed. 42 for and 12 against, 2 abstain, so it's adopted. And then we have compromise 22, 22nd. Vote is open. Thank you. The vote is closed. 55 for, 1 against, 2 adopted. And the next is compromise 23rd. The vote is open. Thank you. The vote is closed. 53 plus, 1 is against, 2 abstains. The compromise is adopted. This is not. 24. Compromise 24, the vote is opened. Thank you. The vote is closed. 54 for, 1 against, adopted. And the next one, compromise 25th. The vote is open. Thank you. The vote is closed. 50 plus and 6 against. Adopted. The next one is on the next page. Is compromise 26. The vote is open. Thank you. The vote is closed. 53 for and 3 against. Adopted. And 27th, compromise 27th, the vote is open. Thank you. 55 for, nobody against. Adopted. The compromise 28, the vote is open. I'm sorry? Yeah. Thank you. 55 for, 1 against, so it's again adopted, and now we can back to the
Recital, compromise 1.
yes, to recital, to compromise first, to compromise 1. The vote is open. We are waiting for the colleagues. Okay, thank you very much. Close the vote. 49 for, nobody against, 2 abstain. We can move to compromise second. Yeah? Compromise 2. The vote is open. Thank you. The vote is closed. 53 for, 1 against. Adopted. Compromise 3. The vote is open. Thank you. The vote is closed. 53 for again and 1 against, 1 abstain. So adopted. Compromise 4. Let's start voting. Yeah. Thank you. The vote is closed. 53 for, 1 against. Not too many? No.
69 is in Liber.
No.
But no, they
the compromise 5th.
Yes.
Starting the votes.
We have 70. We need to one member should remove
one remark. We have 70 members of the committee voting now, which is 1 2 more. I don't know who.
Somebody from Econ probably has the hand. Okay, close the vote.
Okay, let's. Oh, now it's 69. Okay, thank you very much. I would like to close the vote. The result is 54 for and 1 against. Thank you very much. The next voting is compromise 6. The vote is open. Thank you. The vote is closed. 54, 3 against, 1 abstain. So it's adopted. Compromise 7. The vote is open. Thank you very much. 51 for, 2 against. Adopted. Then compromise 8. The vote is open. Thank you. 51 for, 1 against, 2 abstains. Adopted. The next compromise 9. We are voting now. The vote is open.
Amendment 46.
Thank you. The vote is closed. 47 for, 5 against, and 2 abstains. It's adopted. And now we have to
vote Amendment 46.
Amendment 46 is we are voting now. Amendment
46.
It's recital 22 by Mr. Ernst. The vote is open. Oh, it's closed. I have no. Yeah, minus. Okay.
Closed.
The vote is closed.
Rejected.
It's rejected. 35 against, 18 for, 2 abstained.
Compromise 10.
We can go to compromise 10. The vote is open. Thank you. The vote is closed. 51 for, 1 against, 2 abstain, so adopted. And then 11, compromise 11. The next voting, the vote is open. Thank you very much. The vote is closed. 49 for, 3 against, 2 abstains. The next, then we have recital 35. Do we have?
Compromise 12.
Well,
Compromise 12.
Okay, it's compromise 12 first. Yeah, the vote is open, compromise 12. Thank you, the vote is closed. 54 for and nobody against, so it's adopted. No.
No, the two amendments which are identical. 64
Yeah, there are two amendments which are similar, which have the same, identical. So 64 and 65 voting together. The vote is open. The vote is closed. Rejected is 39 against, 15 for. We can go to the next amendment 66. The vote is open. And the vote is, well, let's decide, closed. 46 for and 1 against, 5 abstains, so adopted. Amendment 67, the next one, the vote is open. Oh, I'm sorry. The vote is closed. It's rejected. 36 against, 15 for, 1 abstains. Now we can move
Compromise 13.
to compromise 13.
No, we did it. We did it.
Yeah, we did it. Yeah, we did it.
So we go now to final vote.
So I think it's final vote. Yeah? Yeah. It's a final vote. The final vote, the vote is open. The vote is closed. Thank you very much. Adopted 51 for, 1 against, 4 abstain. Big job is done. Thank you very much. And now we can rearrange a little bit our venue. I would like to ask my colleague, Otmar Karas. Maybe you will lead the voting.